acting on its behalf with I guess, permission with a power of attorney.
I can't let you appear, sir. I cannot let you represent him in the courtroom here. I can't.
Okay.
Let's
I'm sorry, Your Honor. When I read through the power of attorney, it gave me those privileges.
Yeah, you don't have to. I'm sorry. I cannot allow a non-attorney to appear.
Okay.
Now, you might have the power, I'm sure you do, if you're telling me accurately, to go hire the lawyer on his behalf. But I cannot let either he has to appear or you have to appear. I'm not quite sure. It says the funds or property are exempt from garnishment by law. And then it says the writ was not properly addressed or is otherwise invalid because there's improper service to an incorrect address. Jennifer, I don't have any response from the plaintiff here.
Judge, let me look in the file. I was out of the office on Thursday and Friday, so if it came in,
You're going to have, I don't want to make people come back if this is invalid. I'll let you go hire a lawyer. Let me just put it to you that way, Mr. Hallman. I can give you a week or two adjournment and you can go get a lawyer.
Okay.
Where was this served at, Ms. Faze?
It was e-filed on Wednesday.
You're talking about your response. I'm talking about the writ. Did you file a response?
they did, Your Honor. They filed a response on the 8th on Wednesday. I was out of the office, so it didn't get attached.
Would you please bring that down?
I'm printing it now.
Okay. I'm going to go on to another case. I'm going to ask you two to stand by and let me take a quick look at that, please. LBNV versus Sandal Taylor, file number 2504738. Okay,
Yeah.
everybody's name, please.
I'm
Good morning, Your
Sandal
Honor.
Taylor. Go ahead.
Lynn Olivier, appearing on behalf of plaintiff.
All
I'm
right.
Sandal Taylor.
I didn't receive anything from you, ma'am.
I called yesterday. She said she received it on the 7th.
Judge, I'm printing that as well. It's a one-page document she filed. It's not.
And plaintiff filed its reply brief the next day on the 8th.
All right.
And we can adjourn this. Defendant said that she didn't get her
Now,
copy.
let me take a quick peek at those, okay? We're going to have to figure out a way to handle that better though, Jen. LBNV
Sorry,
versus
Judge,
I understand. We'll talk about it. LBNV versus Hancock, Brian T. Hancock, 2600624 GC. The parties here on LBNV versus Hancock.
Your Honor, and which case are you calling, Your Honor?
LBNV versus Brian T. Hancock.
Okay, Your Honor, I have not had either party check in on that one, neither attorney.
I'm glad I was gone for a week. This is how things are going to start out today, huh? Okay, Jefferson Capital versus Joe Tostage, 2600218. Is anybody here on that? John, can you turn the thermostat down, please? Sure. Is anybody here today besides?
Your Honor, both I'm here with defendant on Synchrony versus counsel.
Synchrony Bing versus Mark Counsel, 2601656.
Good morning, Your Honor. Jay Bagg, P36820 on behalf of plaintiff.
Mr. Counsel, you're going to state your name and I'm going to ask you to take your hat off, please.
Now,
Mr.
what you say?
Counsel,
I'm sorry. Yes.
okay, stay with me now. I need to see your face. I'm looking at the ceiling. There you go. Tell me your name, please.
Mark Counsel.
Did you guys talk about this, Mr. Begg?
Yes, at this time, we're unable to settle it. If we can just get a scheduling order with some discovery, that would be great.
You owe this amount, Mr. Counsel?
I don't know. I know I don't owe that amount.
Look at me, please. Wait. Look at me,
I'm
please.
at work right now. Yeah, I'm at work, kind of watching my surroundings. I'm at work. I'm a truck driver. Yeah.
You're not
I'm sorry.
driving, right?
No. I'm parked at the dock, but I gotta keep an
Sir?
eye on this light. Yeah, I'm sorry. Go on. I'll try and say, keep it out. Look at the mirror.
Are you
peripheral vision.
driving?
No. Look, I'm sitting in the parking lot. I'm at
Well, then what's prohibiting you from looking at me? Just look at me.
Yeah. I can't even see you, to be honest.
Mr. Counsel, listen to me. They think that you owe $4,269.87. Your answer to complaint is, I want to settle out of court. Sincerely, Mark Counsel. I'm just asking you, do you owe this debt?
No, I did. I know it wasn't that much. I don't know if they put.
How much
interest on
was it?
Can't remember, sir.
Well, then how do you know it wasn't that amount? Listen to me
It
very
wasn't-
carefully. Mr.
It wasn't
Counsel,
that amount.
Mr. Counsel, look at me,
Yes.
sir. You're looking ahead. I want you to look at me.
Okay, sir, I'm a truck driver, but okay. I got to watch my surroundings, make sure nobody tear up my stuff. I got a lot of people just driving back and forth around here. Okay, but go on. I'm sorry. I'm working like you are.
Listen, I'll tell you what I'm going to do. Mr. Begg, I'm adjourning the pretrial. Defendant to appear in person. I don't need you getting smart with me, Mr. Counsel. You're
I'm not
working
getting
like
smart
I
with
am.
you.
Really? Counsel, I think you should just file your motion. You do what you want. I'll set it for pretrial in 2 weeks. I'll set for
Thank you.
pretrial in 2 weeks at 8:30, defendant to appear in person. What date is that going to be? The
The
27th?
27th, Your Honor.
You have to be
Yeah,
in person December 27th of
So,
26 at
it'll be a
8:30 in the
Yeah.
morning. If you don't show
Yeah,
up, I'm going to default you. Have a good day. Thank you.
Yeah.
Shut
Thank
up.
you, Your Honor.
I'm not in the mood to hear this nonsense this morning. Granite Valley versus Ronald Allen Bodges, 2600001.
Garrett Levine for the plaintiff.
Okay, I need you to,
Okay.
there you go.
Good morning.
All right.
Your Honor, we did writ him out of Wayne County. I've not had the county log in yet.
I don't know what to tell you. Why don't you just do whatever else you got to do, Mr. Levine, and mute us, and when they come in, I'll call them, okay?
I have a 9:30 pretrial with you. I think it's with you. So
You can just check back in. Well, I don't want to keep the county waiting if they're putting them in front of the camera there.
I'll be ready for it.
So just mute us. Okay, thank you. Orbit Leasing versus Preston Rhodes, 2601249.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff.
Is Preston Rose here?
Yes, I'm here, Preston Rose.
Your name?
Preston Rose.
Did you two talk, Mr.
We have, Your Honor. There's settlement discussions ongoing. At this point, I'm just requesting 60 days of discovery and time for motions if needed, but I'm pretty sure this is going to get resolved before then.
Give me 1 second here. All right, just give me 1 second. And Mr. Kuipers, it's Matt Kuipers. Kuipers, and your P number is 71348.
That's correct. And I'm filling in for the attorney at record, Jeremy Chisholm.
All right, I'm going to give you until September the 15th of 26 to conduct discovery. Witness lists are due on August the 15th. I'm putting down 1/2 hour for trial. You don't have to file a trial brief. If you choose to, it has to be filed and exchanged not later than 7 days before the trial date. All motions and responses, I don't want witness lists. I don't want that kind of thing, but anything that's a motion or response to a motion, I'll need a second copy, marked judge's copy. We're going to give you a trial date. All motions for summary have to be filed and heard not later than 20 days before the trial date. Why don't you give me one, Jennifer, for the latter part of October?
October 20th at 10:30.
At 10:30, okay? So that'll be, I'll send out the pretrial order. And you should have that, I would think, by Thursday or Friday, okay? Anything else,
Thank you,
Mr.
Judge.
Kuipers?
Nothing on this matter, Your Honor. I do have a 9 o'clock for Capital One and Brandy Regan.
Okay, let me see if I can pull that out. Any questions, Mr. Rose? So I'm gonna let you conduct discovery. If you think they have documentation or any other item that will help prove that you don't owe all or part of this debt, then you can request it in writing from them. Okay, sir? So you have a couple months to do that. And I wish you well. I'd encourage the two of you to continue talking. It's okay? Any
Thank you.
questions, Mr. Rose?
No, sir.
All right, good luck. Thank you.
Your Honor, if I may, there was a Samsung device.
Samsung device, I need you to identify yourself. We have no clue who you are. SM5F9 is on the screen. Samsung SM5 or F9. You have to identify yourself. Samsung SM F9, you have to identify yourself. You have to start your video and tell us who you are.
Judge, I've tried taking them to a breakout room as well in order to identify them. I'm going to go ahead and remove them.
Thank you. LVNV versus Myron Covington. 2601895.
Yes, good morning, Your Honor.
Good morning, Your
name,
Honor.
Mr. Okay, Ms. Law, good morning. Your name?
Attorney Brittany Law, P83917, appearing on behalf of plaintiff.
And Mr. Covington, your name?
Myron Covington II, sir.
All right, did you two talk, Ms. Law?
We did, Your Honor, and we reached an agreement in this matter.
Good. Tell me what it is.
The defendant has agreed to pay a reduced balance of $2,400 over 24 months of $100 a month, and that will begin August 14th of this year and be due on the 14th of each month thereafter.
And is the total judgment amount going to be for $2,400 even if he doesn't pay? In other words, you get credit for any payments, but if, let's say he makes 4 payments, are you saying it's then going to be reduced to $2,000?
Correct. We did talk, if he misses a payment, it will go back to the original amount of $2,978.
And is this in the form of a consent judgment or conditional dismissal?
Consent judgment.
So, sir, do you understand what Ms. Law just told me?
Yes, Your Honor.
She tells me that you've agreed to pay $2,400 with the understanding you'll pay $100 per month. A judgment will enter in that amount commencing August 14th and the 14th of every month thereafter until paid in full. So long as you make those payments, the balance will remain $2,400 less any payments received. So if you pay them all, that's it. You'll be done in 2 years. If you miss a payment, then the judgment amount, they're going to file an affidavit of non-compliance, and the judgment amount will reflect the balance of $2,978 less any other payments that you make. Do you understand that?
Yes, Your Honor.
You agree to those terms?
Yes, Your Honor.
And does Ms. Law have your permission to sign your name to this proposed consent judgment?
Yes, Your Honor.
Any questions at all, Mr. Covington?
No, sir.
All right, you are all set. Thank you very much. Good luck.
Thank you.
Thank you.
All right, you too. Thanks.
Midland Credit versus Lynette Cloud, 2601416. John, they brought some paperwork here. I told them to put up here. Let me see what you just grabbed. That one you can say. Yeah. All right. Do I have anybody on Midland Credit versus Cloud?
No, Your Honor.
This is gonna be called Chase a Lawyer Day again, huh? What was the other case that you didn't have anybody check in?
LBNB versus Hancock. It's an SD motion.
Have somebody call them each. If nobody answers and nobody shows, I'm simply gonna dismiss the case. Jeff, Stamson Billy Alohi versus Sucre Singh and Michigan Truck Driving School, Inc. 2601776R. Anybody here on that?
I don't have anyone on Zoom, Your Honor.
At what point am I gonna just start dismissing cases? That's the question. Man, I don't understand this. Did I call Orbit Leasing versus Preston Rose yet? What happened with that? Nobody here again on that?
No, that was for the pretrial.
Oh, yeah. So that, okay, my fault. All right. All right. This is SoFi Lending versus Timothy Hallman. 18R2629. John, you have that down.
Good morning. Again, Your Honor, Andrea Faze for the plaintiff, P76952.
Okay, and Mr.
That should have been, and I think it's that one right there, the binder.
Oh, thank you. Mr. Hallman, your name?
Robert Holman.
I'm gonna have you take this. You're gonna have to get a lawyer. How long will it take you to get that for your son? Here you go.
At least a week.
I'll adjourn it. Let me give you 3 weeks. We'll adjourn this 3 weeks. And you can make sure you get a lawyer here. Oh, I'm not gonna be here that day, am I? Yeah. Adjourn 3 weeks to what would that be? The 3rd?
Yes, Your Honor. I was going to ask you actually if we could add an afternoon that week. So could we do it at 1 o'clock on that Monday, the 3rd?
Yeah.
Okay.
What do I have in the morning? I can't do in the morning.
Probation and department reps.
August 3rd at 1 o'clock, we'll do this, okay? I'll have the motion heard, but you have to bring a lawyer, Mr. Coleman, okay?
Yeah, very good, Your Honor.
All right. Anything else that anybody needs to bring up before I set this aside?
I'm not from plaintiff, Your Honor. Thank you.
No, Your Honor.
All right, we'll see you guys on August the 3rd at 1 o'clock. Thank you very much. Have a great day.
You too.
You too.
All right. Is anybody here that has a case, right? Anybody where I don't have to call lawyers or have the staff call lawyers?
Your Honor, Mr. Kuipers is here on Brandy Reagan. They're ready.
We're ready.
Which one?
Capital One versus Reagan. 1617 is the case number.
Capital One versus Brandy Reagan, 2601617.
Good morning again, Your Honor. Matthew Kuipers on behalf of the plaintiff, P71348.
Ms. Reagan, you have to unmute and tell me your name, please.
My name is Brandy Regan.
Did you two talk and try to resolve this?
We did, Your Honor. Same situation. Settlement discussions are still ongoing. Plaintiff's just requesting 60 days discovery and time for motions, but I'm hoping this will get resolved before motion is filed.
Great. All right, so this is what I'm going to do, Ms. Reagan. I'm going to give you the same dates that I gave on the last one, and you can correct me if I'm wrong on any of these dates, Jennifer. September 15th will be the discovery cutoff. Witness list, I'm sorry, September 15th will be the discovery cutoff. There's no jury demand. There will be no settlement conference. Witness lists are due on August the 15th. You have to file a witness list, Ms. Reagan. You don't have to file a trial brief if you choose to. You have to file and exchange it not later than 20 days before the trial. I'm sorry, 7 days before the trial date. No motions will be heard on the date of trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. Okay. Let's see. What did you give me again as a trial date on these, Jennifer? October
20th, correct, at 10:30.
Perfect. So I will send these out. Ma'am, I want to know if you have any questions for me at all. Discovery is the exchange of information. If they have documentation that you think will show that you don't owe any of the debt or not as much of the debt as they claim, you can request those documents in writing. You could send them written questions called interrogatories if you so choose, okay?
Okay.
And I'd encourage you two to keep talking. Do you have any questions for me, ma'am?
Yeah, you said that I'd have to file a witness.
A witness list disclosing the names of all your witnesses by August the 15th.
Okay.
If you have witnesses, you might not have witnesses.
Okay, just myself.
Okay. But that's all I can say about that.
Okay.
If you have any other witnesses, you need to add them on that witness list too, okay?
Okay.
Anything else, Mr. Kuipers? Here you go.
No, that's it, Your Honor. Thank you.
You guys have a great day. Good luck to you, Ms. Reagan, CD.
Thank you.
Thank you. Capital. Oh,
Your Honor, on the LVNV versus Hancock, Miss Law is going to handle that one. I just have to get a call into Mr. Strauss's office now.
you guys didn't resolve this, Ms. Law? Why are lawyers not showing up?
I'm sorry, Your Honor, I'm trying to look into that. It wasn't on our calendar for today.
Well, it was on everybody's calendar for today. But what time did we have it scheduled, Jennifer? I just don't understand. If I got out here an hour and a half late, they'd be complaining about me. But lawyers showing up more and more late like this, it's just disturbing to me. It's like, how far are we gonna go? How sloppy are we gonna be?
Your Honor, we had it for 8:30 this morning.
Yeah,
Sorry, I
so
was
he's
leaving
not
Mr.
here and it's
Strauss a message.
9:25. I mean, if you want to hear your motion, ma'am, I'll be glad, Ms. Law, I'll be glad to hear it. I'm just not going to have us chase people around anymore. We're not babysitters over here. You want to argue it? Well, I'll tell you what, you can call him, tell him if he doesn't log in by 9:30, I'm hearing your motion. Okay, thanks. Christian Financial versus Austin Ortega, 2503014.
Good morning, Your Honor.
Good morning. Your appearance?
Elizabeth Butler, P80956 for plaintiff.
Where's Austin Ortega? Do you know?
He did
Your
not
Honor,
appear.
He didn't, did he send you the items?
Only some of them, Your Honor, and I received them yesterday afternoon. I looked at them. Still do not have everything we need. We were here on June 29th, and you generously gave him until today just to send us the documents so we could cancel this hearing. And he emailed us that he does not intend to appear. He didn't give me everything. I would ask that the court consider a motion for bench warrant. He knows he's supposed to be here.
You know what? I usually require a show cause, but you know what? He was here. He didn't bring what he was supposed to bring. He was going to send it to you. He knew the hearing date. I agree with you. I'll issue a bench warrant. How much do you want? What is the amount of the judgment here again?
For today, it's $6,787.60.
Bench warrant to issue $2,000, okay? 2,000 cash. You can
Understood.
submit that. I'll make it 2,500. That's just not right. We ignored court orders. That's what I'll do. Thank you very much.
Thank you,
And for
Judge.
the
You and your
record-
clerk have a good day.
And for the record, I'm sorry, give me 1 second here. This was scheduled for
9
What-
o'clock, Your Honor.
9
Right.
o'clock?
Yes,
Yeah,
Your Honor.
9, now 9:27. Thank you. Have a good day.
Thank you. You too.
Samsung device, can I get your name, please, or I'm going to disconnect you? Judge, on the LV, or I'm sorry, Midland versus Cloud, I have left a message for plaintiff's counsel on that one as well.
Which one?
Midland Funding versus Lynette Cloud. No one appeared, neither party, and I did leave a message for plaintiff's counsel on that one as well.
What's happening? What's happening? Really, I guess I should just start dismissing cases. Maybe people will learn.
Your Honor, we have Teresa Roberts and Brookston escaping in the courtroom.
LVNV versus Teresa Roberts. 2601897.
Good morning, Your Honor. Attorney Brittany Law, P83917, appearing on behalf of plaintiff.
Ma'am, your name? Did we just adjourn this for another pretrial or something?
We did, Your Honor, but the defendant has paid this in full. We are sending in a stipulated dismissal this afternoon.
Okay, so you're dismissing the case with prejudice.
Correct.
Okay, is that, you understand that?
Yes.
And she has your permission to sign your name to this case, the stipulation that will dismiss the case with prejudice, meaning that they can't bring the action again arising out of this event transaction recurrence. You understand that?
They did send me a letter and then I sent it back, but they didn't get it in time to dismiss for today.
Okay, well,
Correct.
you're gonna send, you're gonna
We
send
just
it
got
in.
her signed one this morning.
I see. Okay, so send that over. I'll just make a note. Defendant was here. Plaintiff attorney here. Case dismissed with prejudice. I'll sign the order when it gets here. Have a good day. Do you have any questions, ma'am?
Thank you.
Good. You don't have to thank me. Good luck.
Thank
Thanks,
you.
Ms. Law.
Thank
All
you, Your
right,
Honor.
so now I also have, I'm calling LVNV versus, Brian Hancock, 2600624. Ms. Law, did you call Mr. Strauss?
Yes, Your Honor. I haven't had a chance to reach his office, but we do have a consent judgment on this one.
Oh, well, that's different. You guys both signed?
I have not received a signed copy back from him quite yet. It looks like we sent it 2 days ago.
Adjourned to July 27th. I'm sure we'll have it by then, right?
Yes,
We'll
we
adjourn
should.
this to July 27th at 8:30. And then I will go ahead and sign the order. Thank you very much. Do you have
Thank you, Your
another
Honor.
one?
That is all I have on my calendar.
Have a good day. Thank you. All
You
right.
too.
Now I'm gonna move on to, where's that? That paper's all over the place here. LVNV versus Sandal Taylor, 2504-738. Okay, appearances, please.
Good morning again, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
And Ms. Taylor, your name, ma'am?
Sandal Taylor.
All right. So this is your motion. And you can go ahead and argue it.
Hi, this is plaintiff's motion for summary disposition. Your Honor, you should have in front of you both the answer to plaintiff's motion that defendant filed last week. And do you also have plaintiff's reply brief to her response?
Right.
Okay. So the last time we were here, we started plaintiff's motion for summary disposition. She admitted that she did have a credit card with Credit One Bank, which is the underlying credit card for this matter, Your Honor. You had ordered the defendant to file an answer to plaintiff's motion, and she did. And she lists 3 arguments. The first one is that she failed to include required disclosures. The plaintiff has failed to include required disclosures. Plaintiff does not know what disclosures she is talking about. She never articulated anything, so plaintiff is unable to respond to that, as plaintiff will not speculate as to what the defendant means. Secondly, defendant states that plaintiff used unlawful debt collection practices. Again, she doesn't articulate what she's means by that, and plaintiff will not speculate on that either.
I can
And for her
speculate
final-
today. I can tell you what I mean today.
And for her final argument, she says
Talking,
that
Ms.
there's no.
Taylor. She's still talking.
I'm
that
sorry,
there's
Your
no
Honor.
I said she is still talking. Don't interrupt her.
Go right ahead.
Go ahead.
She, for her final argument, says there's no proof of ownership. That is incorrect. Plaintiff did provide the bills of sale. Defendant, however, is a non-party to the assignment, and she lacks standing to challenge the validity of the assignments. But plaintiff did show that each bill of sale is signed by the respective party to be charged, i.e. by an authorized representative of the entity that is transferring their accounts. And further, each bill of sale contains language to the effect that it is transferring, assigning, granting, or otherwise conveying accounts to the entity that is purchasing the accounts. And this type of language creates a valid assignment under Michigan law. Plaintiff therefore has valid proof that it is the owner of defendant's debt. Thus, defendant's final attempt to create an issue of fact in an attempt to evade liability for a debt that defendant does not deny incurring must fail. And plaintiff requests that its motion for summary disposition be granted at this time, and then judgment be entered for plaintiff and against defendant for the full amount paid.
Ms. Taylor, this is basically a letter. I adjourned it last time when you told me you didn't receive the motion. I gave you another opportunity. This is a letter. And it's not, I understand that you're representing yourself.
Correct.
But you still, there's still a smidgen of rules that you have to comply with. And you don't comply with anything here. There's no counter affidavit. There's no documentation that you have attached to anything here that creates a material issue of fact. I mean, there is no genuine issue as to any material fact. I'll let you say whatever you'd like to say for the record, but and you can feel free to tell me why I shouldn't enter judgment, but.
Your Honor, the plaintiff has failed to give me original documentation that's signed. According to the Fair Debt Credit Practices Act, they are using misleading information to get money from defendants. They haven't given me anything stating that I have a signed original contract with the creditor. There's nothing. They have not given me that.
Anything else that
I
you
don't
want
have
to
they-
say? Sorry.
I believe that they have not given me an original signed credit agreement. The original contract, they have not given me that, stating they can't prove to me that they own this debt, Your Honor.
Okay. Anything else, Ms. Olivia?
No, Your Honor, plaintiff rests on its pleadings.
Defendant has failed to raise. First of all, I have to take all the evidence in the light most favorable to the non-moving party here, but even saying that with a letter basically that's 3 lines addressing the case, or I guess 4.5 lines, there's nothing that creates a genuine issue as to any material fact. The court finds there is no issue, no genuine issue as to any material fact, and will enter judgment in favor of the plaintiff. You have 90-80-04 in terms of the principal amount. What kind of motion fees and costs do you have?
Costs of $111.02 plus a statutory $20 attorney fee for a total judgment amount of $1,111.06.
You said 111.07, didn't you, in costs?
111.02.
111.02, and you're saying $20 statutory attorney fee. You said this to me last time. I don't know why they're only adding in 20 instead of 75, but they're entitled to 75. But if you want to limit it to 20 again, that's fine. That's 131.02. So do I have $1,111.02? Is that the total amount you're asking for?
6 cents, 1111.06.
Where's the other 4 cents come from? I thought you said 02 on the cost, 111.02.
The damages are $980.04.
You're right. My apologies. I thought it was, you're right. Thank you. So it's 1111.06. You submit your judgment, and I wish you well, ma'am. Good luck to you. Thank you.
Thank you. Have a good day, Your Honor.
You too. Thanks.
Thanks.
Tom Parisi versus Brooks Landscaping. Are we ready on that one, or do I have another quicker one here to go through?
Your Honor, this one will be quick. Mr. Parisi did not appear. Mr. Parisi contacted the court this morning, says he has no mode or means of transportation to the courthouse, so therefore he could not get here. He was requesting an adjournment. I told them that that would be up to the court on whether or not it would be adjourned.
He
He
only
has
lives
had the
in
date for 30
Brownstown,
days.
right?
Yes.
I mean, like,
He says he's disabled and cannot get here, but he doesn't have the ability to Zoom either, because I did ask that question.
your name?
Daniel Brooks.
I mean, he had to figure out a way. How do you get here and get the paperwork filed, you know?
He mailed it in, Your Honor.
Well, you had to figure out between that time, which was back in June, the early first week of June,
Yeah,
and now.
Yeah, he had about 30
Did he-
days.
I mean, if he can't use Zoom and he can't get here, I don't know what I can do for him. I'm sorry, he can file a motion to set aside the dismissal, but. And I feel bad, but. You know. He got to show up somehow. He could have, I don't know how badly disabled. I feel badly for him, but. He's either got to learn how to Zoom or get here. I'm going to dismiss the case. You're all set. Thank you. Thank you. How about Samson Billy, Alohi versus Sakral Singh and Michigan Truck Driving School, Inc., 2601776.
Your Honor, Mr. Alohi was the Samsung that we could not get connection with. He called the court. He's on his way here, but the defendants have not checked in with me.
Were they served properly?
This was a removal from small claims to general civil. And I believe it was removed by the defendants.
Well, but I'm gonna end up giving them a judgment if they don't show up. I'm gonna give the plaintiff a judgment. Rogers is not checked in, right? Do I have Midland Credit versus Cloud? Lynette Cloud, 2601416. Is anybody here on that one?
No, Your Honor, I left a message with plaintiff. Oh, I'm sorry.
My name is Philippe Cicchini. I'm here on behalf of Midland Credit, but I'm here for Lisa Robertson and Ladero Garner. I don't have I don't have the notice to appear for the one that you're calling right now, but I'm here. So if the defendant's here, I'd be happy to speak with he or she in the breakout room if that's allowable, but.
What was this up for, Jen?
Your Honor, I'm pulling it back up. It just says hearing.
It was a hearing regarding
Was this regarding the alternate service request?
service.
Because they were requesting non-tacking.
Yeah, I require 3 things, and one of which is tacking. Mr. Cicchini.
Yes, sir.
So that was a problem. That's why I set it for hearing. I'm not going to just let you mail by first class and certified mail. You're also going to have to tag. So I've been doing that for decades.
I understand, Your Honor. This is the first I'm hearing about this case this morning. Like I said, I'm here to appear for 2 other ones. So if someone can provide me the case number, meanwhile,
It's 2601416. 2601416.
Okay.
So you can look that up. Are you here on Garner?
Yes, sir.
Midland Credit versus Ladero K. Garner. 2600458.
Morning, Your Honor. Philippe Cicchini on behalf of the plaintiff Midland Credit.
Mr. Garner, good morning, sir. Your name?
Good morning, Your Honor. My name is Ladero Garner.
Good morning to you. Did you 2 talk, Mr. Cicchini?
Yes, we did, Your Honor.
Any resolution?
Not today, Your Honor, unfortunately.
All right. I'm going to do the same thing on this one. September 15 is discovery cutoff. September 15 is discovery cutoff.
Okay.
And you have 1 L there or 2. It looks like 2 L's in your name, right, sir?
Are you speaking with me, Your Honor, sir?
Yes.
So Philippe, Philippe. So 1 L in my first name, if that's what you're referring to.
My eyes are going on me, among other things. And that's 69928, right?
Yes, sir. 69928.
All right. So, Mr. Garner, do you owe this debt, sir?
No.
Okay. I'm going to give everybody discovery until September 15th. There will be no jury trial. Nobody made a jury demand. Witness list due August the 15th. No settlement conference.
I didn't see theft.
I'm sorry?
I didn't see theft. Good morning, Your Honor. My name is Ladero Garner. I respectfully dispute the plaintiff's claim. I believe this account is
So, sir, what I'm going to do is I'm going to give you court dates and cutoff dates. You have to file a witness list disclosing the names of all your witnesses by August 15th. You have to file a discovery cutoff, which is the exchange of information. If you think they have something that you think will aid in your defense of the case, you can make a written request for it. If you want to send them written questions, interrogatories, you can do that. I'm giving you guys until September 15th to conduct discovery. I'm giving you guys until August 15th to file your witness list. We're going to set a trial date on October the 20th at 10:30 a.m. You do not have to file a trial brief, but if you choose to file one, it has to be filed and exchanged, not later than 7 days before the trial date, and all motions for summary disposition have to be filed and heard, not later than 20 days before the trial date, okay?
okay.
Do you have any questions for me, sir?
No, I don't.
I wish you well, sir. Good luck. Anything else, Mr. Cicchini?
Not on this one, Your Honor.
Have a great day. Thank you. Here you go, Sadie. All right, Jefferson Capital versus Cassie Harbison, 2601006.
Good morning, Your Honor. Mimi Kalish. My P number is 52383 on behalf of the plaintiff.
Good morning, Ms. Kalish. Ms. Harbison, can you tell me your name, please?
It's Cassie Harbison.
Okay. This is simply a pre-trial, right?
It's a date and time for a motion for summary disposition, Your Honor. Let me make sure of that. Yes, it is.
I don't think I have that, Jennifer. Did you file a response, Ms. Harbison?
No, not this last time. I only did the first court date. I don't think I understood that I was supposed to.
Do you agree that you owe this debt?
Yeah, I never said I didn't. Yeah, I do.
Okay. So you can just give me a little bit of background here, Ms. Kalish, and I'll be happy to.
Sure, Your
Yeah.
Honor. This case originated with Comenity Bank. It was a K Jewelers credit card account. The amount in dispute is $2,472.32 plus court costs and a statutory attorney fee. It's brought under MCR 2.116, C9 and or C10. It's plaintiff's position that Ms. Harbison has not put forth a valid defense, nor are there any material facts at issue for the court to decide. We're asking the court to make a decision as a matter of law and to enter a judgment accordingly. As I said, the principal balance is 247232. Court costs are in the amount of $151.48.
And does that include your statutory attorney fee?
It does not. I'm not seeing the statutory attorney fee, and sometimes that's in accordance with the client guideline. It doesn't appear that this Jefferson Capital allows for the statutory attorney fee. I am getting a total proposed judgment in the amount of $2,623.80. And if the court needs me to break down the court costs, I can do
No, I
that.
don't. Ma'am, do you have anything you want to say? You agree that you owe that amount?
Yeah.
Court is going to find there's no genuine issue as to any material fact. Judgment will enter in favor of the plaintiff and against defendant. 2,623.80 is the total amount, and you can submit your judgment. And I hope you'll work out a payment arrangement with them, Ms. Harbison, so they're not garnishing wages and everything.
Yep.
Good luck to you both. Thank you very much. Have a great day.
Thank you,
have another one in
Judge.
front of me by chance, Ms. Kalish?
I don't have any more today. Thank you,
All
Your
right.
Honor.
Have a good day. Thanks.
You too. Thanks.
Good luck, Ms. Harbison.
Thank you.
Midland Credit versus Lisa Robertson, 2601444.
Good morning, Your Honor. Philippe Cicchini again on behalf of Midland Credit.
Your name, ma'am?
Lisa Robertson.
Any resolution on this one, Mr. Cicchini?
Yes, Your Honor. The defendant and I had an opportunity to speak in the breakout room this morning, and we have reached a resolution for this one. If you'd like, we can put it on the record. The defendant has agreed to pay the debt owed of $1,267.34. She has agreed to make payments of $25 per month beginning on August 1st, to be revisited in 1 year to see if the payments can be augmented. And the defendant has given me permission to sign on her behalf, Your Honor.
It's in the form of a consent judgment, true?
Yes, Your Honor. I apologize. Yes, in the
That's
form of a
okay.
consent
Ma'am,
judgment.
do you
Yes,
agree
yes,
to
Your Honor.
those terms?
Yes, sir.
So you agree that you owe 1,267.34, and you are agreeing to pay these at the rate of $25 per month beginning August 1st of 26, correct?
Yes, sir.
And also with the understanding that that installment payment order, you got it worded, counsel, correct me if I'm wrong, that the installment payment order may be reviewed on motion of either party on or after August 1st of 27. Is that correct?
Correct, Your Honor.
You do?
Yes.
Okay, perfect. Any questions, ma'am?
No, sir.
And does Mr. Cicchini have your permission to sign your name again to that proposed consent judgment?
Yes, sir.
All right, you are all set. I sincerely wish you well. Good luck. Thank you very much. Have a good day.
You too, sir. Thank you.
Thanks. Jasmine Owens, have a good day, Counselor. Or do you have another one?
Your Honor, I guess I'm just trying to get information from my paralegals regarding the cloud case. I just have an update on the information we received from the process server. So I don't know if you'd like to recall that one. I'm looking at it right now in real time. I'd be reading to you as the first time I'm seeing it. So if you give me a moment, if you want to call a case and come back
Take
to me.
your time. Take your time. I'll go on to another case. Jasmine Owens versus Fountain West, 2601734R. Anybody here for Fountain West, Jen?
Yes, Your Honor. Mr. Levine is here as well as a representative from Fountain West.
Okay, Mr. Levine, you're representing Fountain West, correct?
Correct.
Your name, ma'am?
Judge.
All right. So this is just a pretrial. Did you two talk?
Yeah.
No.
I'm going to go ahead and set it for discovery cutoff dates and witness list due dates and that type of thing. Okay, ma'am? So here's what I'm going to do. And you can feel free to talk to Mr. Levine at any time about the case and see if you can resolve it. Discovery is permitted. It's to be completed by September the 15th of 26. No motions will be heard on the date of trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. Nobody demanded a jury trial. You do have to file a witness list disclosing the names of all your witnesses by August the 15th. I'm putting down a 1/2 hour for trial. There will be no settlement conference date. You do not have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. The trial date will be on October the 20th of 26, and that'll be at 10:30 a.m. Do you have any questions? You understand what I mean by discovery? If they have documentation that you think you would like that will bolster or help your case, you can request it in writing. Well, this is just a pretrial. And you have the right to conduct discovery now. What I'm doing is for 60 days. So you guys can exchange information. And if they have an objection, they'll tell you. But I suggest you call Mr. Levine. You're saying that the apartment was in an unsanitary and uninhabitable condition?
Yes,
Let me see. Do you have your photographs?
I had the flash drive, the video, and I gave you guys photos, leaving April.
Did you check into this, Mr. Levine?
Yes, I did. And she never took possession of the apartment. And my understanding is she was planning on moving in with another unauthorized occupant. When that came up, that's when all these issues arose. So these are move-in costs. She never took possession of the apartment. At issue is whether or not she would owe these move-in costs. We believe she does. And if she believes she doesn't, then I think that is a triable issue for Your Honor.
Well, you didn't file a counterclaim, did you?
No, just an answer.
Okay. All right. Look, I'll just set these dates. You guys can talk. And if it's not resolved, we'll simply have our trial on October the 15th at 10:30. Okay.
October the 15th at 10:30.
Anything else, ma'am? Here you go.
October 20th.
Yeah.
What did I say? What did I say? I'm sorry.
You're switching it up on us.
October the 20th at 10:30. It was off a week. I'm a little rusty today.
20th, 10:30. Got it.
Have a good day. Thanks. And I'm going to call your Bodges case as soon as he gets here.
Well, it's an 8:30 case, and I've got some time. I got court. So,
Jen, did you say something?
Yes, Judge. Lisa has emailed the jail because we were questioning why he hadn't been logged in yet. So we are waiting for a response.
An 8:30 case, Your Honor, and I've got court. And if you'll allow me to go on mute, and I'll come back when I can. But this is.
Yeah, go ahead and do what you got to do. I mean, I don't know why.
It's an 8:30 case involving allegations where the defendant beat up his neighbor with a baseball bat. It was filed in January. I think we've had hearings going back since February, March, April, May, June. Now he's in jail probably for a good reason. It might be appropriate, Your Honor, that we enter a default judgment. But
well, how can I do that?
No answers. No answers been filed. No attorneys appeared for the defendant. The defendant's not present. Written to be.
Not a second. I've taken the position, I can't remember who was appearing from your office. I believe it was Mr. Landman. Am I right?
Mr. Landman's on personal leave right now, but yes.
Okay. Well, that's fine. I hope everything's okay with him. He's a good man. But the fact is that I was the one who said we cannot proceed on a termination of tenancy case when somebody would be incriminating themselves. I cannot proceed to a trial and have lawyers peppering questions at him when when the incident that's
I'm not asking for a trial.
both is the felonious assault issue. And he's in custody and this jail screwed up. Again, I believe this is the second time. Am I right or wrong, Jennifer?
Your Honor, this is the first time I've attempted to write him out. Last time we were unaware he was in jail.
I feel for you. I'm
not asking for a trial. I'm just asking for a default judgment. And
he's in custody. How can I do that? That's not fair.
Notice was sent, but Your Honor, it's not fair that his neighbor got beaten in the head with a baseball bat. It was
listen, it might be.
The other neighbors have, it's less of an issue because he's in jail, but at some point, I think we do need to entertain a default judgment. If you want me to wait for the jail, I can wait, but I need to get to another one. So if I could come back.
But listen, Mr. Levine, I don't know when the trial is scheduled. I'm not going to go forward or make him go forward before the criminal trial. I'm just not going to do it. I understand your frustration. I get it. If this was for non-payment of rent, it would be a different story. It's not fair for a judge, and it might very well be overwhelming evidence. I don't know. It could be. I think I did preside over the preliminary exam, I think. But maybe it was a waiver. I don't remember, but now they had a competency exam, I think. So I'm just going to put it out again. I'm sorry. Give me a date 3 weeks out. We're going to give it August. Is it the 3rd, Jennifer?
3rd at 1 o'clock.
At 1 o'clock. If you feel that strongly and you want to write a brief and tell me why I'm wrong, I'll be glad to review it. I am not always right every time, but I just cannot, under these circumstances, enter a default judgment when his failure to appear is based on the fact that he's in custody and the county didn't put him out there. Just can't do it.
If we serve him with this notice while he's in custody, would you entertain a default judgment the next hearing?
Serve him with what notice?
Notice to appear for August 3rd at 1 p.m.
How can I, in this case, for a termination of tenancy, I can't do that. If you think I'm wrong, you can file a brief. And I'll be glad to listen to you. Read it, think about it. But I just can't imagine me changing my mind on this. This is not right. And I'm not saying that I feel sorry for him in the least, especially if he's convicted of a felony. But
a violent felony involving his neighbors, the allegation.
I know, but wait a minute, Mr. Levine. You and I always get along good, but there is this thing, as you know, there's this thing called the presumption of innocence. This is the United States of America. They have to prove the case beyond a reasonable doubt, and maybe they can prove it beyond any doubt whatsoever. But I can't just make the assumption because there was a charge levied that he's guilty. I mean, geez, if I do that, you should even want me off the bench.
I'm not asking you for a guilty conviction, Your Honor. I'm just asking for the civil judgment, and it's a different burden of proof. It's a civil, it's preponderance. Oh, thank you. Well, I had to ask. And I appreciate it.
Thanks a lot.
We'll see you on the 3rd, 1 p.m.
Thank you. Yeah. Excellent Repair LLC versus Waymo Freightliner LLC. Do I have Excellent Repair LLC here? That's right. Are you guys opponents? Oh, you're both for Excellent Repair. Okay. Where's Waymo Freight LLC? Your name, sir? You got to spell it for me. Will you do that, please?
MOHAMME.
And your last name, more important.
ALALYAWI.
Okay, thank you. And ma'am, what is your name?
Stephen Farage.
Can you?
YFARAJ.
Thank you. Jennifer, was there proper service here?
Your Honor, it was served by certified mail. Should be a printed and attached to your packet.
Well, somebody signed on behalf of the company at 419 Cedar Avenue South in Minneapolis, Minnesota. Who's the principal of this? You both or what?
That's fine.
Oh,
I mean, we're both partners and
well, then I'm gonna ask you both to raise your right hands. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth self you got, sir?
yes.
Ma'am? Okay, so what happened here? Who wants to tell me?
So this is a customer that we usually do work for every now and then. He's not from here, he's from Minneapolis. He has a fleet of, I don't know, multiple trucks, and he always comes to us and we always fix his units. So he called us, he was all the way in Monroe, Michigan. He said my truck was overheated. One of my guys went and did a road service for him. The water pump was leaking everywhere.
You did work to the tune of $3,127.10, right?
That was before that. That was, I mean, that's how it all started. I was talking, well, on this case, 3,000. Yes, that was in the shop, but before that, we went and did a road service for him. And we changed the water pump, but the actual water.
He didn't show up. They didn't show up. Listen, did you bill them $3,127.10?
Yeah, we fixed his truck, he took his truck and he left, he didn't pay the bill.
Yeah, that's terrible.
We contacted the driver and the driver said, he told me, hey, if you have an issue with him, I have an issue with him too, he's not paying me either.
Great.
So.
Jennifer, give me a judgment. You're gonna get a judgment here for $3,127.10 plus you have a $70 filing fee plus you have a certified copy charge of $12. So that's $82. So that should be $32.09.10. Do you have any other out-of-pocket costs? Why don't you guys wait around? Jennifer, will you prepare that judgment?
I'm typing it now.
3,127.10. And then $82 in filing and service fees for a total of $32.09.10. Wait around, I'll sign it. As soon as she brings it down, I'll have my court officer bring it down. And then you're gonna be all set and take that copy of the judgment. I'm sorry, you're gonna have to go through that.
Thank you so much.
Have a good day and good luck to you both. What else do I have? Okay, counsel, I'm gonna call that Midland Credit versus Lynette A. Cloud, 2601416. Good morning, Mr. Cicchini. Your name?
Good morning, Your Honor. Philippe Cicchini on behalf of the plaintiff Midland Credit.
I'm sorry, I'm mispronouncing your name, aren't I?
It's fine, Your Honor. People have been doing it my whole life. You are completely free and clear of any of any guilty feelings. You're fine.
Apologize. What'd you find out about Lynette Cloud?
Your Honor, thank you for giving us the time to do a little research. So yes, we found on the process server's website that the following comment was entered by the process server. This is Ranco Rancilio is the process server in this case, Your Honor. The note that the process server entered was, please note, server reported threat at this address after first attempt. We will not be sending anyone back to this address. We will be attempting via certified restricted mail. And then there's the following note on 4/19 at 12:39 p.m. No answer at the door. There's a car in the driveway, left notice. The process server then noted.
Wait, give me 1 second. Hang on.
Your Honor.
I'm
Yes.
gonna take this right there.
Yeah.
All right, go ahead.
Okay, and then the process server left the following annotation. I received a telephone call from a male extremely threatening from a number 313-622-5897. Just a side note, Your Honor, I did go into the defendant's account. That number does match up with a phone number we do have for Lynette Cloud. So again, resuming the note here, I received a telephone call from the male extremely threatening. He told me to stay the F away and threatened bodily harm if I return. I wasn't certain who it was, so I sent him a text and I told him in the text that you asked me to stay away, but I don't even know who this is because you didn't tell me your name or address. So he sent me that information, and that is how I knew it was for this defendant at this address.
When does the summons expire?
Oh, okay. Let me see if I have that, Your Honor. I'm sorry. We're having technical issues where I can't pull up PDFs right now. Let's see if I have that information.
Oh, I see it on the notes here. It says expires September 4. I'll grant your motion. Send your order in again. If we, do we have it? Do we need him to do that again?
Judge, we should have it in pending, waiting for this hearing. So
I'm
I'm
gonna go ahead
checking
and
right
sign it, and if Jennifer, follow up on that with me, please. Make sure I sign that. If we need more information, not more information, but if we need another order, we'll contact you. Otherwise, I'll sign that one.
Okay.
Okay?
Appreciate it, Your Honor. Thank you. Have a great day.
I see what happened now.
Okay.
I didn't have that information available to me.
For your
Thank
Honor,
you.
just for my information, so are you, this was a hearing that was scheduled for this morning at 8:30, is that correct, Your Honor? Is it, or the clerk, if someone can?
Yes, Your
confirm
Honor. Yes, it was scheduled for 8:30. We mailed notice to your office on that.
Called you, Your Honor. You just got the motion, Mr.
that?
Sorry, Your Honor.
Appreciate it. Okay,
Good
yeah,
day.
we'll look into it, why this was missed by any counselor or hearing counsel this morning. Obviously, we don't want that to happen in the future, so we'll look into why this was missed. So our apologies for that one, Your Honor.
No problem. Thank you.
Okay. Thank you. Have a great day.
Jefferson Capital versus Joe Tostage, 2600218.
Good morning, Your Honor. Sazan Barda, P 65425 on behalf of the plaintiff Jefferson Capital.
Is Mr. Tostage here, Jennifer?
I don't have Mr. Tostage or his counsel.
Guys, you can go right down the hall. I signed that. Thank you. He's not, the lawyer isn't here?
No, Your Honor. I'm showing Mr. Langston as defendant's attorney on that.
What do you want me to do, Mr. Barda?
Your Honor, today's the date time set for a motion for summary disposition. I will say that I have hundreds of files with this third-party debt consolidation firm who hires Mr. Langston. He has never opposed any motion out of the hundreds that we filed. If our motion is granted and a judgment enters, that's not going to stop this from resolving with the debt consolidation firm, who is actively contacting our office, and we've had numerous conversations with. So today, plaintiff is respectfully requesting that our motion for summary disposition move forward.
Grant your motion. I'm gonna go ahead and grant your motion for summary disposition. There's no genuine issue. It's any material fact. You're entitled to it pursuant to MCR 2.116C9 and 10. Just give me the breakdown, if you would, Mr. Barda, please.
Yes, I'm pulling up the motion here. I just want to make
Take your
sure that
time.
it was attached. I don't think it was attached, so I will have to submit an order for entry, and so the
Got-
court.
I've got it's 357560. Got a filing fee of 75. You got a service fee of 41040, and you also have the statutory attorney fee coming up 75.
We do not charge the statutory attorney fee. We do charge the $20 motion for summary disposition fee.
So
the only-
you've got,
Your Honor, I'm sorry. I walked away from my computer to give that copy, and Mr. Langston has logged in.
Oh,
Mr.
perfect.
Langston, your name?
Good morning, Your Honor. Matthew Langston.
He's argued his motion essentially.
And we have no opposition to their motion, so.
I'm gonna grant the motion. He's entitled to principal sum of 357560. He's got 11604, 13604 in court costs. It should be 371164. Is that true?
That's true.
That sounds correct to me as well.
All right. Judgment will enter in that amount. I'll ask you to send that over, Mr. Barda. You two have a
Thank you,
good
Your
day. Thank you,
Your Honor.
Thank you.
Do I have J&B Medical Supply? Jeez. Versus Deanna McLean?
Yes. Christina Codrington for the plaintiff.
Good morning, counsel. How are you?
I'm good. How are you?
Ms. McLean, your name, ma'am?
Hi, Deanna McLean.
Any resolution on this?
The account's been paid in full. Our office is filing dismissal.
Your office is going to file a dismissal?
Correct.
Did she pay in full?
Yes.
So you're gonna submit a stipend order to dismiss
Yes,
with prejudice, correct?
yes,
So you understand and agree to that, ma'am?
Yes.
I mean, it's in your benefit, and she has your permission to sign your name to that document?
she's already signed it herself.
Oh, perfect. All right, send it over. Have a good day, everybody. Keep
Thank you.
smiling. Good luck. Thank you.
Thank you.
Wouldn't you tell me again about Aloha?
I believe he may be in the courtroom. He was a Samsung device we couldn't connect with. So he was gonna come here to the
Son,
courthouse.
Aloha?
Mr. Sings.
Come on up here, sir.
To the podium.
2601776R. Your name, sir?
Samsi Ivory.
Nobody showed for defendants, right?
No, Your Honor.
Did they file an answer to the complaint?
Yeah, they got say yes.
I don't know why they didn't show up. There might be a valid reason and they might not. Defendants failed to appear. This is a pretrial. Defendants failed to appear. Default judgment will enter. I'm going to give you the following amount. You prayed for and you are entitled to $4,075 in a principal sum. And then you had court costs. You had $110 in filing and certified fees. So 70 filing, two charges for certified mailing, 18 and 12. So you have court costs there in the amount of 100 plus. I think that's it, isn't it, Jennifer? So I'm gonna enter a judgment amount of $4,175 in your favor and against the defendants. They were supposed to be here at 8:30. I know you had a problem with your device. You couldn't connect, and so we told you to come in. You're here. They're not. You win. We'll send the judgment out to you, okay?
Thank you, sir.
I wish you well. Good luck. Thanks. Is that it?
We have a defendant on Zoom who lives in Detroit. She has 3 warrants. And she wants to be arraigned.
She can't make it here? Well, she's gonna have to make it here. Who do we have on?
Her name
who's-
is Ashley Stevens. She's in Zoom. She said she has no transportation from
Where's she
Detroit.
live?
She's in Detroit, she said, Your Honor.
How old are the cases?
2022.
Oh, well, hey. If you can't find a time to get here, she's gonna have to show up. Give me a break. She's got 3 warrants from 2022. Come on. Tell her the judge said she has to appear in person. And if she doesn't, the warrants are gonna remain in full force and effect. Thanks.
You're welcome.
All that shouting last Friday, you did. Don't go out today. Did you ever go home or have you been just sitting here over the weekend? And I stayed the whole weekend right here. Well, we get to start with you on the top. You've got Wyman Clubber.
He's here. He's in the back, all the way to the back.
And what do we do with Mr. Clubber?
They come up. Look, I had that one with Mr. Helms.
I don't see Jimmy.
He is in Polk County on special prosecution.
So what do we do with it? I think I'm gonna dismiss it.
Okay.
Can I do that?
You may.
Okay, I think I'll do that. Just respond.
Hey.
Hold on, Mr. Clough. You have a right to be heard. Do you object to that?
No, you better.
Good, smart move. Smart move.
Yeah, you better not.
Hey. All right.
Just have a seat. I'm using.
You're.
Hey, that definitely wouldn't move the case, right?
That's one way. Here we go. I got James Franklin. Is up next. Why are we whispering? We're on YouTube.
I think Mr. Gertz has a secret.
Yeah.
Okay.
My
Well,
secret
let
vacation letter.
the 50,000 people hear it. Go ahead.
Judge, I've got a vacation letter in for starting
When?
Wednesday and through August the 3rd. August the 2nd. Yes. Sunday.
Did you know that?
I did, Judge, and I don't think that I think that if we can't go, he can't go. That's my,
Say that again.
if we can't go, he can't go.
She's talking about, she wanted to pack herself in my bag. She said,
It's not the way I understood that.
well, that's what she told me. I can show you the text, Judge.
I was reading today. People don't think rationally. They think of emotion.
That's a true story. That's a true story.
I knew that though, Judge. We talked last week.
So what do we do with this with Frank?
Reset it on the next available trial docket.
Sure.
After the August 3rd? Yes.
So what would that date be? So he gets, everybody knows to be ready and let's try this and then first.
Check in.
31st of August?
Yep.
Thank you, Judge.
One. There you go. Samiski. Who's on that? Mike, do you have Samiski? Say. Probably.
We're missing a witness on that, Judge.
So you want to dismiss it?
No, sir.
Mr. Hammy informed me that they were going to be seeking a second autopsy.
After 3 years?
I'm just what he.
I mean, 2 years?
He mentioned it to me. I told Mr. Ham, I don't know if those were said anybody, so. But I'm ready, but I'm not. Those were said.
Were you handling that for him?
This is Mr. Ham's case, Judge. He just left us a note that he is missing a witness on this case. And so he's asking for a resetting on it.
Reset. I say, so we have Killingsworth is reset as well.
He's in TDC and I didn't know that until last week. They have his name spelled differently than what we have it. So looking him up, I didn't find it.
So what do we set it to?
4 weeks to do the bench warrant to get him.
Put it 6 weeks. 6 weeks.
I have vacation letter off in August.
All in August?
Well, 20 working days in August.
That's 6 weeks. What's 6 weeks from today? It's not the end of August.
Yeah. Are you good?
You're good. You're.
31st?
Sorry,
Are
man.
you good the 31st of August?
Oh, yeah, we got a trial setting on 31.
It took you before 5 day segments. We don't know.
Say that again?
About 20.
Month of August is what.
Well,
you want.
20, yes, basically.
So when are your segments?
With the weeks of lunch, before the 4 or 5 day segments. Because you're only allowed 20 days.
I know, yeah, I know. Where the heck are you?
Nowhere, just not here.
Wait, nowhere is not here.
Right.
Okay.
It's not where I'm going, it's where I'm not.
I'm trying to work with that phrase and see if that was slanderous or if that was
That's what I took it as,
compliment.
Judge. I took it as very slanderous.
Yeah, 254,000 people got upset just now.
Sure.
Are you even wearing socks today?
Yes. No.
Okay. Fine. So that's what it is. And Glover Jones is the same thing.
I'll do the paperwork.
Wait, is there anything else? That looks like it. Okay.
Yours is a clean.
Okay. Does he need to get out or is he?
I've already signed.
Okay, good. Yeah, we're going to be coming up on that in about 5 minutes. Thanks. John Dixon.
Ready, Judge?
Ready, Judge.
Who said ready, Judge?
Myself and Mike.
Someone like
This is not Jimmy's case.
Someone
I'm ready.
from that table.
Matthew Sharp. That's you? Do you have an attorney or are you gonna?
He's not here.
Where is he?
I have no idea.
Well, y'all ready? Is this state ready?
I'm ready.
Well, then we're ready. It's
Defense counsel.
500 days
The
old.
one who told me he wasn't ready.
Well, you didn't tell me that, but that's 500 days old. Y'all get ready. Glover Jones, Joey Childress, Laurie Perosa. Where's Miss Perosa? Anybody know? That's Mr. Laird. You ready on that one?
Sure.
Jeremy Broussard. Who is your attorney?
Jason Bailey, sir.
Who's handling this for Mr. Ham? On that. We got a bunch of attorneys who don't show up for the trial document. Good Lord. What's that all about? And that's generally a priority. But did we even hear from any of them?
No, I have not.
Well, I think all of their bonds are revoked. Wish we could do it.
This case just got, was this Jeremy Broussard? It just
It
got
is.
re-indicted on July the 8th. So I don't know anything else about that. Hadn't heard from Jansen Bailey this morning.
I tried to hold him. I couldn't. So.
Well, I mean, this like a Twilight Zone episode again. Kendrick Antoine,
Me, Judge.
Where's our you?
Terrence Jarman, Mr. Macon.
He's here. It's trial.
Are you that's a Ham case.
What's the number? Operation minimum of 25 years. That he rejects seeking.
Okay, here's the deal then. Dixon's 1. Sharp is 2. And Childress is 3. And then we got Broussard and Jarman, but those are Mr. Ham's. And we'll call them 4 and 5. Okay, Glover Jones, let's get that. Disposed of. Yes. Mr. Jones.
I need his sponsor.
You don't need Kindler's sometime?
No.
They're going on the lesser included first 2 years study.
I'd like to run Kindler's something really and ASICs and see what we can come up with.
Okay.
Here, right over here to this lady, please, sir. Thank you.
Now we don't have all those straight down. Okay, 2 more times anywhere on the page. Okay.
Yes, someone.
Give me a summary of what we're doing on, Mr. Jones here.
Just heard it statement.
If that one.
Okay, hold on. Okay, this is a second-degree felony of robbery.
Yeah.
He was an habitual felon 3 convictions ago. And we're pleading it to state jail.
It appears to be the case now.
Is that what we're doing?
That's what I understand from Mr. Hanson.
Y'all gotta talk to me about this one. Now, how can,
Mr.
I don't care, he was indicted as a,
I understand you.
may I speak? He was indicted as a, serious felony offense, crime of violence.
The way that
He has 4 prior felony convictions. He was an habitual felon 2 felony convictions ago. He was a habitual felon in 2013.
I know to say that there's a piece of vital evidence missing a video, and also there's co-defendant had something. I don't know who the co-defendant was. We look.
the representative report, not discussion for this. He indicated to me that he reviewed the file and he told me the facts corresponding to the person.
Correct me if I'm wrong, but robberies are done with theft being a part of the elements of the offense. You have to commit a theft to get a robbery.
That's why it's a lesser included.
I know that, but that's not the way grand jury indicted.
Trust Mr. Hanson about the question you're in.
Well, they asked the prosecution asked for the grand jury.
I can only put my
Presentation.
I can only assume that Mr. Ham upon further evaluation of these facts and actually the idea of having to present the cat facts to the jury was comfortable with it being a theft in the person as far as his level of proof. This will be like predicated.
I'll see if there's anything Mr. Laird can. Because I'm answering what this too. It's a rare event and I.
Evidently, the co-defendant investigated. 1 year county jail. After revocation of probation, got 2 years probation, then got a revocation for 1 year. What happens?
That's all y'all can really see. I'm looking at probable cause. It's not wrong. Anything else?
Doesn't look like anyone was hurt. Seriously, just had the scuffle.
Yeah. If we go to more, second sheet of.
Nobody knew what that was when they brought it to grand jury. Why do and ask for a grand jury indictment on a robbery? Presumably.
It's the issue with the horizontal system. I can say in Orange County, just as a point of reference, that there's a vertical prosecution. Some of the cases presented, it was presented by the attorney that's going to try the case. So there's a little bit different perspective on the cases that are actually divided.
Yeah. You don't see anything readily though.
I don't see anything to really cause you to reject it either, Judge. It's a shoplifting that
I'm
was
not gonna take it.
a scuffle at the end.
I'm not gonna take it.
Okay.
We'll just move on.
Well, then we'll need to reset it to
I understand.
renegotiate.
It's not gonna be placed on, it's not gonna be placed in trial today.
Yes, sir.
All right.
Kinder Antoine, Mr. Manal, I guess. Okay. Cases do you have? Two?
Just two.
Oh, they clean the boat or?
Just one.
Which one?
And one, he's paying to, gonna be the 1606, and then 1607 will be dismissed.
Okay.
I don't think I have this. Oh, 7 is the dismissed. Yes, Reagan. Here's one. It's Tom's. And so
I don't have.
I sent it on the house.
Well, I know it's on there, but I don't have it. It was never pulled. Yeah.
Oh, yeah.
Yes, Rob. If we can reset, I mean, we call it, Judge, and I'll figure it out. I'll sort it out.
It's a pretty.
All right, I'll do.
One more.
Yeah, what's the last one? That was good. And if we could put that on recall and then go upstairs and grab a file, please.
They just have to go grab it.
Yeah, see.
What do I have now? Is, okay, once again, it's Dixon, Sharp, Childress. Broussard, Jarman, in that order.
We had short term.
Yes, sir, welcome.
Thank
Uh-huh.
Apologize.
We've been here for a little bit. What are we gonna do?
I'm already.
Why not?
This is our very first setting, and it was just last weekend. Mr. Hanson, experts. There. Was bad. We can actually come back on this one. Once it's not that old, I got retained on it's just last year on this. Is that right?
Just last year.
I was just, it's not my first trial setting and see what happens. Experts cost a fortune, and so you try not to do all that unless it's going to be absolutely necessary. And I'm still not convinced trial is necessary, but not resolve it without may end up being some type of a open plea in jail.
This was sent for jury trial today back on March. But then in June,
we came
got
back.
something in June.
We came back in June because the client's father communicated with the grandparent and created an issue.
Okay, when do we try the thing?
We could put it on a setting in September, or October.
What
Do
do we
my
have?
best to get my experts.
September 14.
14. September 14th.
Lindsay.
There we go.
Thank you, Judge.
What else do we dispose on today? Are you Mr. Antoine? Yes. Come on up. Greg. All right, once again, which one is which? 1607 was pleading.
1607 is the dismissal. 1606 is the plea.
25 CR 1606 is called your tender Antoine with Ms. McNally, your attorney and the state's attorney does. The defendant waived formal reading of the indictment and arraignment to proceed in summary.
Yes, Judge.
In summary, the states that on or about October 13th, 2025 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer.
We did both. Oh, okay.
Okay, in 25 CR 1606, again, you were Mr. Antoine, your attorney and the state's attorney. And again, in summary, on or about October 13th, 2026, 2025 in Jefferson County, Texas, this state you committed the second-degree felony of assault on a peace officer by kicking the complainant in the stomach with your feet, and you knew the victim was a peace officer lawfully discharging an official duty. Do you understand which was arresting you? Do you understand what you're charged with? Yes.
Yes. That's my right.
This is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. You understand?
Yes, sir.
An agreement's been reached with you would be pleading guilty. So 2 years in prison. And then the other case, N607 here, would be dismissed. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney. Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
No objection.
without objection admitted. This states you are mentally competent to enter your guilty plea as freely and voluntarily made. You know what you've been charged with, the indictments and the read to you. You read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
You understand what you did wrong here?
Yes, sir.
What?
Assaulting a police officer.
Sir?
Assaulting a police officer.
Well, I mean, what do you think about that?
That
I'm sorry.
I mean, I apologize about it. I mean,
Were you in your right mind?
wait,
Huh?
no, sir.
Why not?
Can't explain this moment. It's just one of those things.
It was just not one of those things. I mean, you were assaulting, and then let's see. You stated some terrible vulgarities. Were you aware of that?
So,
You want me to say them out loud to the general public, or so that we all know what kind of person you really are?
no, sir. Not a bad person at all, sir.
Oh, I'm sorry. It's not what we think we are. It's how we act.
Right.
Isn't that right?
Yes, sir.
How did you act here? Poorly. Correct?
Right.
Right. You are mentally competent to enter your guilty plea, the court finds. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. As you have given up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, I now find you guilty beyond a reasonable doubt of this assault on a peace officer, a second-degree felony offense. I'm following this agreement. Hereby sentenced to confinement in the institutional division in the Texas Department of Criminal Justice to serve a term of 2 years. You understand what has happened today?
Yes, sir.
Anything else?
No, Judge.
That is all.
Thanks, Judge.
I think I've got a dismissal on this too.
We don't have it yet.
I'm sorry, there's. Mr. Lear?
Yes. Yeah.
Okay, on that last case, y'all are gonna give me a dismissal, right, State?
Yes, sir.
Uh,
Working on my answer.
Yeah, don't get it.
Sure.
Leslie Foreman.
Yes, Your Honor. We set that case 1 week to give him an opportunity to decide if he was taking 10 years. I believe that he is a habitual felon, so I just wanted you to put on the record.
I need
That's
to.
all.
Where is he? He's in custody?
He's in custody.
Oh, God. Okay. 20 pounds here.
Wait a minute.
Who's on this one?
Mr. Coleman.
What's he gonna do?
Are you on that one or who's that?
He's saying he doesn't.
No,
Oh.
it was now.
I just want to put on the record.
We don't have a DA on that yet. But we have it off.
It was 10 years, but he gave him 1 week to think about it. So I just want to put on that he's going to accept it. That way, because I think he's a
There's
bit.
a candy folder that says plea rejection if you guys want to use that. I don't know they reject it.
Okay.
Throwing that out there.
Yeah, we have these. You don't ever use them.
I know, right?
My last month in the army.
Other than-
All right, 26 CR 293. Who's the state on this one?
I will be judge.
Leslie Foreman. Yeah. Okay, you can work from there. Then, you're charged with a 3rd-degree felony of failing to comply with sex offender registration. Do you understand this? What was the offer on this?
The offer was 10 years, and I believe that he's an habitual offender.
Twice. He's been an habitual offender status 2 convictions ago.
Mhm.
So you're looking at, if convicted, no less than 25 years in prison up to life. Do you understand?
Yes, sir.
All right. And do you understand 10 years is less than 25 to life?
Yes, sir.
Okay. You thought about this and what do you want to do?
Trial, I guess.
Go, this is your life statement. Go to trial, I guess.
I talked to my family, I don't want to take the team.
Huh?
I don't want to take my family over to the so.
They're running your show? You don't have independent thought? I mean, it's you're the one that goes to prison, not the family, right? Okay, all right. Are they working with you or against you? Do you know?
With me.
Okay, all right. All right, so here's, you're not eligible for probation. We're gonna place this quickly, all right?
Yes, sir.
And this is your last shot at this, but I don't accept anything after the next minute. You've thought about it. This is what you're going to do, right? Then that's your destiny. No deal. We will place it first. When can we set this? Can you be ready in 6 weeks?
Yeah, that's fine.
All right, we're going to try this in 6 weeks.
All right, so your attorney's waiving, you have a right basically to wait 24 hours from the time that you receive the indictment to be asked to enter a plea. The court's Mr. Kathman is waiving that 24 hours, so we're going to go ahead and arraign you today. The court will enter a plea if not guilty for you. There are 2 charges in this indictment. One is a F5 aggravated possession of drugs. The other is an M4 possession of drug paraphernalia. So the court's going to enter a not guilty plea on your behalf. Your attorney has already filed motions for ILC, intervention in lieu of conviction, on your other case and this case. So we're going to be ordering that assessment, and someone will be over to assess you. Do you wish to be heard on the issue of bond?
Your Honor, if I
She's being
could-
held without bond on the other case, correct?
That's correct.
All right, so I'll set this bond on this case at a recognizance bond, and she's going to be held without bail on the original case.
I know, you know.
Could we address bond on the other case?
You can address it.
Her husband is here today. She has a place to live. I think there's some evidence of a drug issue, but just hang tight. I think the time she spent here in jail has driven home the point that she needs to not avail herself to the treatment that's going to hopefully be offered to her, and go that route. I don't think she's a threat to anyone other than herself, and maybe some type of EMU where she's restricted to her home would suffice. Just ask that you consider that as an option for her. She doesn't have, from what I understand, minimal to almost no record, correct?
I don't have that record.
Okay.
And I know when the outpatient.
Ms. Nicholson, do you wish to respond?
Your Honor, I would just indicate that the new indictment comes from a home visit that was conducted as a part of her. She must have been out on a monitor, but community corrections went out. She had meth at her house. That was after the first incident where she had been charged and was out. She was on a GPS monitor. I don't know what the level of care is going to be that's going to be recommended after an assessment. I have no objection to once that assessment comes back if there's an appropriate placement for her. But I think she has shown that going back to her home maybe isn't the best environment, but we'll otherwise defer to the court.
Her husband would like to address the court if that's okay.
Okay.
You have to come up here and state your name for the record.
State your name for the court of order. My name is Jason Weber. I'm the husband of Holly. The person that was coaching Holly when I wasn't home is actually now in your Warren County Jail and probably will not be out for a while. Holly was clean for 7 years. I, as a husband, neglected her to look more at the streets on the people that I try to get in help getting into rehab and stuff like that. I'm currently in school, getting ready to get my bachelor's in psychology and addiction and mental health. And I know my kids miss her, my granddaughter misses her. Yeah, I mean, it's rough doing alone. But
Yeah, you have to speak up.
But I can assure you that there's nothing in my house anymore that can coach her to go the opposite direction. And I have several people, other females and stuff that I work with that are going to work with Holly outside of her other treatment that she gets.
Is she engaged in treatment now?
Yes.
When? When did that happen?
She is engaging in the Warren County Jail.
Okay.
What was she doing outside of the jail?
Outside the jail, she worked and sat at home.
Where do you live?
Huh?
What's your address?
155 East Broadway, South Lebanon, Ohio.
All right, Ms. Weber, I will reinstate your previous bond with electronically monitored house arrest. And again, you will be tested. If you were, you get to make choices here. I mean, if you make
Yeah,
bad
I've already
choices,
had it.
well, I don't need you to respond. I need you just listen to your attorney. He will speak on your behalf. You actually picked up another felony while you were out on bond on this, and that is clearly unacceptable. So either you follow the rules or you sit in the county jail. I will give you this opportunity to show me that you can do this. So I will reinstate your bond with electronically monitored house arrest. Anything else?
Thank you very much.
All right, that's all.
Ed, I need your signature.
That's that one. Bryant Williams.
Yes, Judge, he's here. Mr. Williams, come on up.
Are you Bryant Williams? Yes. Okay.
Yes, sir. This is Mr. Williams.
Where'd the probation office come? Oh, there he is. Okay. Langston, you're representing Mr. Williams here. And Mr. Williams, you know, you're charged with the second-degree felony of robbery. You're looking at up to 20 years in prison. You understand? Yes, you have to speak out so she can hear you. Just help us. Okay, good. You're kind of soft voice. Okay. What are we doing on this?
Hey, Judge,
What are we doing on this one?
what I was hoping, I'm sorry.
I'm looking at the probable cause. Yeah, I always have to read this stuff.
Just what I was
But
hoping.
we got an issue here, right?
No, and I'm hoping that we can resolve it today. If Mr. Laird is still in a good mood on dismissals. Look.
Where's his
I'm
father?
hoping, no, come on up, Mr. Williams.
Is that what you want to do?
I'm
Bring him up?
hoping so.
He's the victim here, right?
Well, that's his dad. That's Mr. Calvin.
Yeah.
Williams.
Yeah.
And then obviously this is my client,
That's why
Brian
we,
Williams.
when you get a familial situation here, we want to walk through this
Just
deliberately and carefully because there's always a good reason that a family member is generally a family member is a complainant and ask for the police to come out and investigate and move forward because of the harm that occurs. But
Mr. Calvin Williams to my right, my client's biological dad.
And the victim in this case, according to the indictment.
He's informing me, but he also told me he wanted to inform you in the DA's office himself that he did not want to pursue any charges against his son.
Why? That I can't believe the DA's office has moved forward without talking to the victim. That's not normally what they do. They never talk to you.
No, sir. And sir, if I can,
Hold on, just a second. Let me know. Let me read through this one. Y'all called the police though, didn't you, for help? Right?
And there's a officer gave,
Well, they put their
Fitch put in his offense report that he asked the victim here if he wanted to proceed with the charges, and he said yes. At the time.
And that might have been at that time, the
I know,
dad is
but
adamant that he does not.
everybody, but law enforcement gets put in harm's way. It costs a ton of money for the taxpayers. And if you call for help and ask and say you want to prosecute it, you're not the guy making, after that, it's out of your hands. It becomes in the DA's office hands, really. And they're the ones that make decision because y'all called for help.
Yes,
And
sir.
y'all wanted something done and they did it. But you don't decide what the ultimate resolvement is. It's important. People, the DA's office always likes to have input, but people just can't call for help and get somebody arrested and then say, now, until next time, I just don't want him, we're not going to prosecute him. We'll see what happens next time. They are the decision makers, the executive branch of government. That's what happens. I mean, people want to hear, they want to hear the victim's input, but it's not fair to everybody. And I'm a taxpayer too. I just pay part of that cost. Either, yeah, it's costing somebody and you just can't later come back and say, okay, I don't want to prosecute anymore. Somebody else can write a check for all the costs involved. And then we'll see what happens next time. When you call for help, you're pretty much committed. And it's out of your hands. And you need to, shouldn't be treating your father this way. I mean, this is biblical. You don't treat your father and commit assaults. Shame on you. Really. If you were younger, you would be getting a spanking, because this is childish actions, sir.
And Judge, just to add on about Mr. Williams, yes, he did make that statement the day of, but just to give you some background on Mr. Williams, I'm talking about the dad.
Yeah, I'm sure he's fine.
No, right.
I think I recognize him somewhere.
Right. Well, I was going to
and I know Calvin. I know another Calvin Williams, who's a very special friend of mine.
But this particular one, Judge, he is a retired U.S. Marine, and he's also a mechanical engineer. So as far as his mind and his capacity, he's had great time to think about and reflect. And he reached
better than that. No, he knows the rules, and he took an oath when he became a Marine. He took an oath.
Right.
And he knows he's got discipline in his mind, I'm sure.
Right. And he's a mechanical engineer by trade as well. But he specifically reached out to my office, and he came to me telling me that he did not want to go forward with this.
I know, but he said he wanted to at the beginning.
Right. I got you. So
so what I it's like changing your mind at the altar. Right. I mean, it can happen, but it doesn't.
Right.
It's not kosher.
But what I told him was, I think it would be best for him to come here and tell that to you and the DA's office, and then
here's the problem, though. Doesn't. Yeah, it's going to be the executive branch, not me. And you open the door for one, you can open the door for everybody. Theoretically, you allow this, we wouldn't have anything to do. Mm-hmm. One person after another can walk up and say, "I've changed my mind now." He got in trouble. He learned his lesson. Well, we're not used as a tool for discipline. Mm-hmm. Well, we're used for something else, a procedure, a process that flows from you call for help, law enforcement goes and investigates it, then they turn it over to the prosecuting authority, the executive branch of government, and then they make the decision. It's out of the hands of the person who called for help. They called for help, and they don't have the prosecution decision authority. These people do. And that's the way it is. But what's good for one's good for everybody. And you start this, and everybody can come in and say, we've thought about it now. I don't want him prosecuted. And what a waste of effort and time. I'd rather be doing something else than sitting up here and making this just something that's a farce. We have rules, and once it gets into the system, you really don't have a lot to say about it. These people have to say. They're in control, but you ask for help, and that's what initiates it. And then you got to follow through with it. But you open the door for one. What's fair is fair for everybody. And the next person is going to come up and say, I want the Bryant Williams rule. Then we have nothing to do, which may be a good thing, but still it's a waste of time and money. And we're talking about taxpayer money and time and effort of arresting him, locking him up, and, you know, people put in harm's way. But there's a system. And once the grand jury indicts, here's the indictment, they reviewed it and they followed through with everything, and they felt like there was probable cause here, that a second-degree felony, a crime that carries with it up to 20 years imprisonment. It's a crime of violence. Those are serious crimes. This isn't a parking ticket. This is something where it's a second-degree felony, which carries with it up to 20 years in prison. We just don't treat these things lightly, or else our jobs are worthless. But there's something to this. We've been doing this since 1787, following the rules, holding people accountable when they commit crimes. Because we're supposed to live in peace. You commit crime, you have to pay, like everybody else does. And but people can't, but Mr. Williams is no longer in control of this, no matter what he says. I mean, he can say, I'm not going to be there, then they can subpoena him, and he's got to follow a subpoena or he gets in trouble. Then he has to come up and sit and take the stand, and they're going to ask him questions, and he has to answer under oath. And we know what his answers are going to be unless he falsified statements to the police, which I don't think he did. So he would be, I mean, this is the way it works. It's a system of rules. This breaks the rule down. But anyway, so we're just set it for trial, I guess.
That's fine.
Until something else gets done.
Yes, sir. That's fine.
It will be set for trial, and that's what will happen.
I can't speak for you.
All right, Don.
What can you do this way?
Brittany Cormier.
Right here.
What are you gonna do with Brittany?
We do not need to bring her out. I'm gonna be filing a motion for mental examinations.
Judge, will we get again, touch?
Yeah. Yeah, before we leave.
Sir.
I'll give one to you and I'll listen to that. So you have someone do this.
Sir, before.
It was Kyle's case, Brittany Cormier. We're not gonna bring her out. I'm gonna be filing a motion for mental exam.
On Brittany Cormier, 26-613. Reset that for how long?
However long till Dr. Gopal can examine her.
Okay, Dr. Gopal will be ordered. You got a motion you're gonna file.
I will file it.
And then if it's sufficient, then Dr. Gopal will evaluate the defendant for competency and we'll come back for an announcement later.
Yes.
Vicarious living.
Vicarious Living has hired John West. He's got some of that guy.
Larry.
Well, but if I get a little time to get that straightened out.
You can do one of those, John. I don't need them.
Okay, not an official one.
Ready to.
All right. Ms. Moore, you're on this. Look,
What project? Living.
Laquarius Living?
Yes, sir.
Oh, so what? Do you, I guess there is a case on a Christopher Elam.
Yes,
right?
sir.
Okay. So these we tread lightly on because we're talking about an infant who has been seriously injured. And apparently Christopher Elam, has he been indicted?
Pretty sure.
Because according to the probable cause affidavit, he was interviewed and confessed to intentionally injuring. He struck the child and fractured the child's femur, the little baby's femur.
Yes.
And then this defendant, Licarius Living, is accused of two things. Assaulting the child. It looks like this was a child 2.5 years old. The defendant here is charged with striking the child about the head and body. And in paragraph 2, by being aware of physical abuse and injury, failing to prevent the abuse and injury, and failing to take the child to medical professions in a timely manner. These are it's a first degree felony, of course, because of the nature of the victimization to an infant. So what's the status of the other defendant?
His case has been, it has been indicted, Judge, and it's set for announcement August 3rd.
August 3rd?
Yes, sir.
All right, where's the defendant now?
She's in custody. Yeah.
Okay. What are we doing today?
Just need to get some time to work over this, and I think we're trying. I think the state wants to focus on the other defendant first, see what kind of what happens. But I need at least 4 weeks just to do my normal, get the discovery.
Okay,
like that.
you said 4 weeks. Billy Wayne McLean.
Ready, Your Honor. Please, make sure he's sworn.
Where it says, right, Tim?
Breaking it.
Just have a seat, sir. Thank you.
Anyway, I'll try. Okay.
Twenty-six CR 598 is called the State of Texas versus Billy Wayne McLean. This is in 26 CR 598, a first degree felony of burglary of a habitation. And then in 26 CR 599, illegal possession of controlled substance. All right. Look at this. This is in the file here. Appears to be a handwritten document that the defendant writes, asking for a mental evaluation. Yeah, those things. Do you know that? Anything about
I
that?
don't know anything about it, but I've visited with him on multiple occasions. I don't see any cause for the mental examination.
What do you say?
He knows what he's doing.
Is that right?
You know what you're doing.
So this, you're withdrawing this request for a mental examination, are you? You have to speak out so she can. What are we gonna do, Don?
Please, Your Honor.
Where are we on this? He's good?
No, Judge.
Let me see. Yeah. Shame on you. Where is it? You? Shame on you. You're testing positive for methamphetamine and amphetamines. That pretty much explains everything. Shame on you. You're on this court. What's his bond?
Hang on. 15,000.
Your bond is revoked. It is $50,000. Plus you must have a GPS device. So I know where you are when you're getting your drugs.
Yeah.
And also you need a drug patch. So I know if you're using any drugs illegally at any time. Shame on you. This is a serious crime. And you're caught. This is a felony offense. We just caught you at another felony. Shame on you. You're taken into custody. That's the orders of the court. One gets out, goes from one mess to another, one mess to another, just more serious. Shame on you. Which one is he pleading to?
Both cases, Your Honor.
All right, you are Billy Wayne McLean. You're gonna start and you understand what you're charged with in each of these cases?
Yes, sir.
Does the defendant waive formal readings of indictments and arraignments here? Can we proceed in summary?
Yes.
In summary, 26 CR 598 alleges, and are we going on just paragraph one?
That's fine.
Paragraph one, it states that on or about October 10th, 2025 in Jefferson County, Texas, you committed the first degree felony of burglary of a habitation. And that is entered a habitation without the effective consent of the owner with the intent to commit the felony of sexual assault of a child. Do you understand what you're charged with here?
Yes, sir.
Do you understand what you were charged with here, sir?
Yes, sir. Yes.
It's a first degree felony, which means you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand
Yes, sir.
the punishment range applicable for this offense? An agreement's been reached where you would be pleading guilty and sentenced to 40 years in prison. Is that right?
Yes, sir.
To run concurrently with the other case, 26 CR 599. Let's see. The state jail felony of illegal possession of
It
controlled
is,
substance.
but it's enhanced to second degree punishment because of priors.
You got a prior aggravated sexual assault of a child in 2001 conviction from the 252nd District Court of Jefferson County. After that was final, you committed the third degree felony of harassment and were convicted of that in the 320th District Court of Potter County, Texas in 2010. Okay. So back to this 40-year sentence. If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty? Are you pleading guilty voluntarily? If that is on your own free will and because you are guilty.
Yes.
Gonna hold that one in abeyance. And for a moment and go to 599. And the defendant waives a formal reading of this indictment, and we can proceed in summary.
Yes.
In summary, paragraph 1 of this indictment alleges that on or about March 17th, 2025 in Jefferson County, Texas, you committed a state jail felony of illegal possession of methamphetamine. You know, understand what you're charged with here. It's a paragraph 2 goes on to allege that you were convicted on February 12th, 2001 of aggravated sexual assault on a child in the 252nd District Court of Jefferson County, Texas. Is that true and correct? As it is alleged in that cause number 77436, and are you pleading true and correct to that voluntarily and because it is true? And paragraph 3 goes on to allege that after that aggravated sexual assault on a child conviction occurred and became final, you committed the offense of harassment, a 3rd-degree felony, and you were convicted of that felony on February 22nd, 2010 in cause number 55528-D as in dog in the 320th District Court of Potter County, Texas. Is that true and correct as it is alleged? And are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
Do you understand that voluntarily and knowingly made pleas of truth to paragraphs 2 and 3 of this indictment is enough to enhance this state jail felony to a state jail felony, though it will be punished as a 2nd-degree felony because of the prior convictions? Do you understand? Yes. That means you are facing, in this case, no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
And in this case, the agreement's been reached, or you would be pleading guilty, sentenced to 20 years in prison to run concurrently with the preceding 1st-degree felony of burglary of a habitation at 40-year sentence. Do you understand how that will apply? And is that what you understand?
Yes.
If I follow this agreement as well, you have no right of appeal of your cases. Do you understand?
Yes, sir.
Well, I'm going to try to raise this on. Awkward device.
Want me to see if I can get it, Judge?
Today, I don't know what's going on.
Do what?
They're like they're lagged differently today. So I got it right. So.
Hold on. All right, once again, how do you plead in cause numbers 26598, the 1st-degree felony of burglary of a habitation, and 26 CR 599, the illegal possession of a controlled substance, guilty or not guilty in each case? Are you pleading guilty voluntarily and
Yes, sir.
because you are guilty, sir?
Yes, sir.
And In 26 CR 599, the state jail felony of illegal possession of a controlled substance. Are you pleading true to allegations 2 and 3, those prior convictions of aggravated sexual assault and harassment as alleged in that indictment? Are you pleading true and correct to that voluntarily in each case and because those allegations are true?
Yes, sir.
And do you understand by doing so, if the court finds you guilty, which I'm going to do in this particular case, that this constitutes a state jail felony, although it is punished under law as though it were a second-degree felony?
Yes, sir.
I show you in each case what's marked as State's Exhibit 1. Did you sign those documents, understand them, discuss them with your attorney, or the contents are true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence in
No
each case without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of each of these crimes in 26 CR 598 and 599. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true of state, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence reports are waived in each case?
Yes, sir.
I'm going to follow these agreements and find in each of these cases you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea in each case because of State's Exhibit 1 admitted in this hearing to find you guilty beyond a reasonable doubt in each case. In 26 CR 598, the first degree felony of burglary of a habitation, you are hereby found guilty of that offense as alleged in the indictment. I am following that agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. And that's and the indictment and the record will reflect that burglary involved the intent to commit a felony offense of sexual assault of a child. And in 26 CR 599, I hereby find you guilty of this state jail felony, but also paragraphs 2 and 3 have been proven true beyond a reasonable doubt, which constitute a state jail felony, punished as though it were a second degree felony. And I find paragraphs 1, 2, and 3 true and correct. And you were found guilty of those 3 allegations, and you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 20 years in that case. These sentences shall run concurrently. Do you understand what has happened in each of these cases, sir?
Yes, sir.
Anything else? That is all. That's all. Thank you. Here. Is this? Eric Norman.
Great honor. So please, we should be sworn as well.
Cases.
Right down. Straight up and down.
He's pleading to both?
Yes, no problem.
Cool.
Yes, ma'am. Yes, ma'am. Good morning.
All right, we are looking at two cases here, 26 CR 852 and 853. The state of Texas versus Eric Lee Norman. And that's you, sir?
Yes, sir.
And you were here with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive formal readings of the indictments and arraignments in each of these cases? Can we proceed? Stop. Yes. Okay, on 852, this is a state jail felony punished as though it were a third-degree felony?
Yes,
Is that correct?
That's correct.
Okay. In summary, 26 CR 852 alleges that on or about January 7th, 2026, in Jefferson County, Texas, you committed the state jail felony of credit card or debit card abuse. Do you understand what you were charged with?
Yes, sir.
Paragraphs 2 and 3 go on to allege, though, that on January 12th, 2018, in this criminal district court of Jefferson County, Texas, that you were convicted of the state jail felonies of theft and cause number 13-17219, as alleged in paragraph 2 of this indictment, and the state jail felony of burglary of a building in cause number 13-18271, as alleged in paragraph 3 in this indictment. Do you understand what you are charged with in paragraphs 1, 2, and 3 of this particular indictment?
Yes, sir.
And this constitutes a state jail felony, as alleged in paragraph 1. But this alleges paragraph 1 that on or about January 7th, you intentionally used a debit card knowing it was without the effective consent of the cardholder. That constitutes credit or debit card abuse, a state jail felony. But paragraphs 2 and 3 do constitute a state jail felony, but it's punished as though it were a third-degree felony because of the 2 prior convictions, as alleged in paragraph 2 and 3. Do you understand that, sir?
Yes, sir.
Which means you were facing a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in this case. Will you be pleading guilty to 6 years imprisonment for the state jail felony, punished as though it were a third-degree felony? This sentence will run concurrently with the agreement in 26 CR 853, that state jail felony we will be going into here in a minute. Is that your understanding of the plan?
Ran concurrent with the other,
The other charges, the other state jail. That means they'd run together.
which other charge? I'm already going 6 years.
I don't know what you're doing.
Yeah,
The 2 cases today, you'd be 6 years concurrent.
concurrent with the other cases, yes.
Yes, everything's on current.
Oh,
Is that your understanding of the plan?
yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
In each case.
Yes, sir.
Hold on, I'm trying to. We are getting a substitute for this device, right?
Yes, sir. Okay.
There is, it wasn't made for a human to use. I don't know what they used as a go by, but you can't, the finger has to depress 2 devices and they're separated. Your finger isn't big enough to hit them both at the same time.
Yes.
As I'm explaining it.
Take your time.
Thanks for bearing with me.
Yes, sir.
Okay. If I follow these agreements, sir, you have no right of appeal in each of your cases. Do you understand?
Yes, sir.
All right, so let's get to the heart of the matter in each of these cases. In 26 CR 852, how do you plead to paragraph 1 alleging the state jail felony of credit or debit card abuse, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraphs 2 and 3 alleging those prior convictions on January 12th of 2018 that we went over, a state jail felony of theft and a state jail felony of burglary of a building out of this criminal district court of Jefferson County, Texas. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct with those voluntarily and because they are true as they are alleged?
Yes, sir.
And in 26 CR 853, how do you plead to paragraph 1, a state jail felony of theft of property, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which alleges in 2016 in this criminal district court of Jefferson County, Texas, you were convicted of theft. And in 2018 in this criminal district court, you were twice convicted of theft cases on that date. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those allegations in paragraph 2 voluntarily and because they are true as they are alleged?
Yes, sir.
And that constitutes a state jail felony. So you've got a state jail felony punished as though it were a third-degree felony in 852, and in 853, you have a theft case, which would have otherwise been a misdemeanor, but because you have 2 or more prior theft convictions in felony court, each time you steal a pack of gum, it's a felony offense from here on. Do you understand?
Yeah, yes, sir. No, that's not.
Best to be honest.
Yes, sir.
You don't have to worry about things. I'm going to show you in each case what's marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney?
Yes,
Are
sir.
the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence in each case.
No objection.
Without objection admitted. Among other things, the state you are mentally competent to enter your guilty pleas today. They are freely and voluntarily made. You know what you've been charged with, and in each case you are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true at state, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Help me out here. What am I missing on this? On 26 CR 853, the paperwork shows a third-degree felony. How is it doing that?
Because of the 2 prior.
No, but the allegation 1 is theft of less than $2,500. That would be a misdemeanor, wouldn't
No, it's state jail.
it? Is it?
Well, so with the 2 priors and then after that, the prior. So there, I don't know what it is. Let me see. Can we slip this?
Your Honor, I got 7 months already.
Hold on.
It's a miss.
Hold on. Yeah, this is
Enhanced.
yeah, this is a
State jail, and you've got 2 prior state jails.
This one doesn't have the 2 prior pages.
Hold
on.
I don't know what they are actually, but they're.
Hold on. Yeah, but those are just thefts. You can't do that. You can't enhance it with thefts. Thefts. You can't do that sentence that he has. He should have alleged these burglary of them.
But it is a state jail felony, isn't it?
Well, there's 2 thefts.
It's just not a third-degree felony.
It's not a 3rd degree, it's a state jail.
Okay, y'all got to write up the papers from.
Yes, sir, we're gonna have to change the offer. Because it can't be 6 years.
Well, on, the first one was 6 years.
Yes, but the second
The
one
second
can't be, second one can't be. It's only
is-
state jail felony.
Yeah, 6 years. That can't be.
So I don't know how.
It's going to have to be a state jail, so it can't be more than 2 years. So you're getting a benefit here. And they're going to have to redo the paperwork.
Judge,
We're
since
gonna
it's
come
not,
back.
it's not going to enhance anything later on because we've already got enough state jails, I'll just dismiss that one. The state jail.
Oh, okay. So 26,853, you're just going to dismiss.
Yeah, it's not going to enhance anything later on. It's not going to help anything or anything.
Okay,
I'll take
hold
care.
on. Hold on.
Yes, sir.
We got a victim here. Whatever's going to happen. This victim is not standing out in the cold with a loss of something that the defendant would have been otherwise responsible for, correct? We got a victim here.
In the offense report, they did say there was $115 loss, but they have not sent anything back to our office requesting us to collect their restitution for them. So.
Okay, so then you're going to send me a dismissal on
Yes, sir.
853.
Yes, sir.
On 26 CR 852, that's what we're standing by. That one will go forward. You have pleaded guilty to paragraph 1, voluntarily, knowingly, intelligently, and to paragraphs 2 and 3, you have pleaded true to those 2 prior state jail convictions. This is, and there's enough from State's Exhibit 1 to find you guilty beyond a reasonable doubt. This constitutes a state jail felony, punished as though it were a 3rd-degree felony. I now find you guilty beyond a reasonable doubt of this offense. I'm following this agreement. We are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 6 years on that case. So you understand what has happened today, sir?
Yes, sir.
All right, anything else?
No, sir.
That is all.
Thank you, Judge. Thank you.
Then the 8th. I'm taking pieces.
Yes.
That way Mike can do the dismissal.
Okay. Is it back in the?
Okay. Yeah.
Kendall Mayfield? Kendall Mayfield?
Get outside it.
He's a plea judge.
He's a plea judge.
Need somebody to play on.
There's such a thing as a plea judge? No, I think I know some who are.
How many you taking?
See that lady first, sir, right there. Thank you. Kendall Mayfield? What are we doing on Mr. Mayfield's cases? He's got a lot of priors. What are we doing?
It's a 1244B town plea judge, just straight up.
This is paragraph 1.
Yes, judge.
He's got other stuff going on that won't for her effect. So.
Yeah, these are all 3 prior.
Yes, sir.
Convictions in sequence. Which would have enhanced into a state jail felony punished as a 2nd-degree felony. We're only doing state jail felony though, paragraph 1.
Yes, sir. Correct.
25 CR 1415, you are Kendall Mayfield.
Yes, sir.
Present with Ms. McNally and your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment in paragraph 1? Can we proceed in summary?
Yes, judge.
In summary, this indictment alleges that on or about July 13th, 2025 in Jefferson County, Texas, you committed the state jail felony of unauthorized use of a motor vehicle. Do you understand what you're charged with?
Yes, sir.
If convicted, you face confinement in a state jail for any term not less than 180 days nor more than 2 years. Additionally, you may be assessed a fine not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty and sentenced to 1 year in the county jail, as the parties have agreed to proceed under section 12.44 of the Texas Penal Code, which states that you can be convicted of a state jail felony, but punished as though it were, a misdemeanor, punished as though it were a misdemeanor. Section 12.44 of the Texas Penal Code, a court may punish a defendant convicted of a state jail felony, which is what the plan is over here.
Yes,
Right?
yes,
We're going to convict you of a state jail felony, right?
sir.
And then we are going to impose, though, confinement that is permissible as punishment for a class A misdemeanor, which is up to 1 year in the county jail. And that's your plan, right? 1 year in the county jail. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty
Guilty.
or not guilty?
Guilty.
Are you pleading to this state jail felony voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that?
Yes, sir.
Voluntarily. Understand it? Discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence and without objection it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1, made a part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
You were looking at second-degree felony punishment up to 20 years in prison in this. Did you know that? You know that.
Yes, sir.
All right. I'm going to find as to paragraph 1 of this indictment, a state jail felony of unauthorized use of the vehicle. You pleaded guilty voluntarily, knowingly, intelligently. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There's State's Exhibit 1 admitted here to support. That's enough to support your guilty plea to find you guilty beyond a reasonable doubt of the state jail felony. I now find you guilty beyond a reasonable doubt of this unauthorized use of a motor vehicle, a state jail felony, in paragraph 1 of this indictment. And the court, upon considering the gravity and circumstances of this felony committed and the history, character, and rehabilitative needs of the defendant, which are required to be considered under this statute, section 12.44 of the Texas Penal Code. It's my understanding that all parties agree that punishment of Class A misdemeanor confinement 1 year in the county jail would serve the ends of justice.
That's correct, Judge.
And you?
Yes, Your Honor.
I will follow that. I hereby find you guilty beyond a reasonable doubt of this state jail felony, and you are hereby sentenced to confinement in the county jail for a term of 1 year. You will be given credit for all time you've served toward that.
Yes, sir.
Anything else to add?
No.
That is all. Thank you.
Thank you, sir.
Yeah, I'm not saying anything bad about that. Okay. Sears and Roberson. Sears and Roberson. Sears and Roberson. Sears Roberson. It's hard not to say Roebuck after you say Sears. And with an R, Sears Roberson. What are we gonna do on this?
There's two motions for revoke probation, where we've come to an agreement to reinstate him with the JDCI as an ad hoc position.
So what are we doing today?
Why had we fill out paper, we're getting him reinstated today.
Reinstate for what?
He was on probation, Judge.
But I don't, there's nothing for me to do, right?
No.
Who's
Mike,
who's the suspect on this one that caused this mess?
we should call for him 3 times outside, just, it would be just to see a probation amendment.
If this is another reduction, I don't want to do anything with it.
He's gonna just.
I think you're running out of straight faces on these cases.
I'm running out.
You can only look serious just for so much of a length of time and then it cracks. You're Sears Roberson, right? What are we going to do with Mr. Roberson's cases? I don't understand here. He's got 2 MTRPs or state jail felony, and it says committing illegal possession of controlled substance out of San
He's got a plea.
Bernardino County of California, failing to provide verification performing community service hours, failing to provide verification of completing the theft prevention class, and being in arrears in his payments on these 2 cases. What was it? These
We're going to abandon the new offense out of California. Those were dismissed. So he's just got the administrative violations.
And
We've agreed to add JDCI as a condition to his probation and reinstate him.
okay.
Everything's pretty much administrative and he needs some judging from that case that got dismissed in California.
Okay.
I think.
Do I really have to do anything here? All I have to do is really modify his probation term, right?
Yes, sir. If he's agreeable to it, we could just do an amendment.
Yeah,
Okay.
he's agreed.
Where's the probation officer on this?
We can do an amended order, Your Honor.
I mean, that's all we need. And then let me sign that. And then y'all want to dismiss these 2 motions?
Sure, why not?
Yes.
Anything wrong with that?
No, sir.
It's more than one way to deal with these matters, and I think that's the most streamlined method. Okay, Devin Westbrook.
Judge, that is one that I was working on and what was gas.
Okay, what do you want to do today?
New case, if I could have more weeks on him.
You got it?
Found that new one on pursuit.
On
Give you 3 exactly.
1, 2, 3 cases on Devin Westbrook's reset 4 weeks.
Yes, sir.
Is that what you want?
Thank you.
I have Renee Avila.
Judge, we're waiting to see, I know this is kind of backward, but we're waiting to see what the misdemeanors do on this, because the felony is apparently an aggregation of the 2 misdemeanors that are still pending in misdemeanor court. I think the state's willing to let him handle the misdemeanors, and then if those get resolved, it's just miss the felony. I think it's the plan for Mr. Oliver. Okay.
Can't believe I got to the point where I'm waiting on misdemeanor courts. I mean, that seems backwards. But what do y'all agree to do?
At this point, just
Things
said
that
it doesn't handle the.
It hadn't made sense for about
Misdemeanor.
19 and a half years anyway. This is not science. Renee Avila.
Yes, John.
26 CR 273, you were charged with a 3rd-degree felony of violating bond or protective orders. Engaging to communicate directly, you improperly directed communications to Debbie Avila, a protected individual, by texting her, repeatedly calling her on the phone, repeatedly going near the residence. Okay. All right, the grand jury indicted this. Y'all want me to get involved in this or not?
If we could get it reset one more time.
Why did the grand jury indict it? Do you think?
Would be the state's call, not mine.
All right, what about it, state? Why did it get in here?
The state's not saying that it didn't happen. I did agree, Judge, to see what's going on with the misdemeanor cases and try to take care of everything at one time. Well, everything with one.
Yeah, but now, what are we waiting on? Why are we waiting on anybody? I thought we were the more serious jurisdiction. I think we are.
We are, Judge.
So I mean, I'm old enough to make independent findings.
Judge, I guess at this point, we're just asking for one more reset so Mr. Elder can handle the misdemeanors. And then if he doesn't, then we address it. Paul, I guess.
And a reducement in my bail. That's really what I'm saying. Around for 5.5 months.
I understand what you said.
He wants a bond here.
See, that's why,
sorry,
that's why we move forward in this court and we have bond hearings.
It's been 5.5 months now.
So. Conduct a bond hearing.
Sorry. To see it.
I got my wife and kids at the homeless shelter. They're waiting on me to give my taxes.
Say it again.
My wife and my kids are at the homeless shelter in Porter with Mrs. Pat, and they're waiting on me to get out so I need my taxes so I can get them out of the homeless shelter.
What's your wife's name?
Debbie Avila. So there's a
well, hold on.
Yes, sir. Yes, sir.
Yeah. You're charged in an indictment here, which carries with it up to 10 years imprisonment for victimizing Debbie Avila.
I understand that, John.
So right here now, you're worried about her well-being?
Yes.
Really? Really? Why weren't you worried about her well-being being August 4th through August 25th of last year? When, let's see. You threatened and harassed her by texting and stating you hated her, threatening to fight her, and that you would urinate on her grave. Let's see, knowingly and repeatedly calling her phone multiple times over several days, and knowingly go to and near the residence that you were all this time ordered.
She's
not
my wife, Your Honor.
You interrupted me, Mr. Rude Man.
Sorry. I apologize, Your Honor.
Yeah, and we can't see, it's just not rudeness, but when two people speak over each other, this court reporter can't take two people, and the Court of Appeals has said that if she can't do her job, someone gets in trouble because they are unable to figure out what's being said. They are the ultimate determiners when a case gets appealed.
Yes,
so
sir.
I don't want to make them upset.
Yes, sir.
I want them to be able to do their job. So it's not going to be my fault. And nonetheless, these are serious allegations that the grand jury brought. And you're concerned about their well-being now doesn't favor this court in any way. I'm more concerned what the grand jury did. All right. What's the state asking in this case?
Judge, I did just make a prison time offer to defense counsel. So I'm not sure if he's ready to make an announcement on that at this point.
Do you know? Have y'all had a chance to talk with that with her?
Not with the offer, but I mean, he is.
Well, we're not going to conduct a plea negotiation on YouTube with thousands of people watching. Get with me on that. Talk to them and see what y'all are going to do and what step we're going to take next. But I will do this. I protect people who are threatened, especially folks who state they will urinate on the loved one's grave. Shame on you for that. That's just terrible.
Can I speak to you, sir?
No, you speak to him. He's your lawyer. He gives you advice. Y'all go up there. It's on you food. Come on. We'll go to something else and let me know when you're ready. But yeah, don't be doing advice giving on you want everybody to hear it, then kind of ruins this sanctity of confidence between the defendant and the lawyer. You've got Javante Beta.
Yes, sir, and he is, where did you go?
If we could pass on that one, Miss Coffin did go to speak with him. I'm not sure. I mean, where she is.
Say that again?
I'll go.
Yeah, you were on the case. He's working with you?
If he's got a misdemeanor pending, that's a result. If we found a misdemeanor reduction, if he pleads to that, they'll dismiss the felony and Ms. Coffin has.
Oh, okay, so that's why there's two different lawyers involved. Okay, Desiree Boyce.
That is a plea, Judge.
Desiree Boyce.
Yes.
You're wearing different glasses today. Or you find something different? It's a different, it's a look, it's a great look. It's a great look. Makes you look like a professor, actually. In fact, I'd like you to test two of these lawyers here. Give them an easy test and see how they do.
I didn't get a chance to study, Judge.
They all say that.
You gotta do the rest. 1 and 3. One.
Either one or three.
Are we working off of a second amended motion to revoke probation? Is that
That's fine.
where we are on this? Okay. Because I've got it, but
That's my
I didn't know if
understanding.
that was the most recent one.
That's my understanding as well, Judge.
Wow, this,
Pleading to allegations.
not 18, but 19 violations here. I've done this a long time. I've never seen a motion with that many. But that does not scare me.
Yeah, it's,
18-30652 is called the State of Texas versus Desiree Monique Boyce. Is that you? Present with your attorney, Mr. Turner, the state's attorney, and the probation officers is here. There is a second amended motion to revoke probation that has been filed. Shoot, that was filed over a year ago. That's what we're going to be working on. Do you understand?
Yes, sir.
Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. Does the defendant waive a formal reading of this second amended motion to revoke probation? Can we proceed in summary?
Yes, Judge.
In summary, ma'am, this second amended motion to revoke probation in this cause number 18-30652 alleges that on August 26th, 2019, well, going on 7 years ago, in this Criminal District Court of Jefferson County, Texas, you were sentenced to 5 years in prison. That was suspended for 10 years probation for the state jail felony of unauthorized use of a motor vehicle. And it was a state jail felony, but it was punished. It looks punished as though it were a third-degree felony, because you had two prior state jail felony thefts in 2018, an unauthorized use of a motor vehicle and a state jail felony of theft were the two prior convictions out of Bayard County that were used to bump the punishment range up from what would have otherwise been a state jail felony, as it is in this case, but it is punished as though it were a third-degree felony. And you were looking at up to 10 years in prison. Is all of that true and correct?
Yes, sir.
We're not going to do all of these. Just give me the bullet points. Which one's she going to plead to?
1 and 3.
And the state would abandon the remainder, Judge.
I'm sorry, it's 1 and what?
3.
Was a lot of effort that was put in here. Because, I mean, this is 1 and 3 were 2 amended motions ago. Were already in there. We could have moved this thing a long time ago.
We have to go.
All right. 1 states you provided a urine sample on or about March 5th, 2021 in Bayard County, which showed the presence of marijuana in your system, which is a violation of condition 10 of your probation order. And get into it. Looking for the probation order. There it is. On the right side. Probation number 10. Order that the court sign when we place you on probation. Do not use or possess any drug. Use of, possession of, and prescriptions of any and all medications must immediately be disclosed to your probation officer. Is allegation 1 true and correct as it is alleged?
No. Yes.
You're pleading true to that?
Yes.
Voluntarily and because it is true.
Yes.
Number 3 states you failed to submit to alcohol and or drug screening on or about November 23rd, December 21st of 2020, March 3rd, April 9th, 2021, at the direction of Bayard County Probation Office, which is a violation of condition 25 of your probation order, which is submit to alcohol and or drug screening at the direction of the probation office. Is that allegation 3 true and correct as it is alleged?
Yes, sir.
And are you pleading true and correct this as well as allegation 1?
Yes.
Voluntarily and because it is true as it is alleged.
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation, such as the second amended motion to revoke probation? Your probation can now be revoked and you can be sentenced to no less than 2, no more than 5 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes.
Or looking at an agreement that has been reached in your case, where your probation would be revoked.
It's still in jail. It's still in state jail. Yeah. So
It's a state jail.
Yeah. So.
Yeah, and this is showing 180 days in the county jail. It's got to be 180 days in the state jail, right?
Yeah, I tell you, the thinking behind it, Judge, is we want to punish it under 1244 of the penal code as a misdemeanor.
I didn't do that.
Well, that's what we would recommend to the court, and I tell you why. She has a sufficient amount of jail credit on the county side to satisfy this.
No, hold on. I didn't do that at the outset of the crime. That's when I should have done it.
Understood.
When I said that I sentenced her to confinement in the state jail. That was at that point in time when she was sentenced was when 1244 should have arisen. It
Yes.
didn't. But I mean, you got no less than 180 days up to 2 years in the state jail.
Yeah.
I mean, that's what needs to be in there, not the county jail. I don't think I have the authority to do that. But what do you want me to do? Change this to 180 days in the state jail? She's going to be given credit for all time she has served, whatever that is. Do you know how much?
Over 400 days.
She's got over 400 days. So she's not going anywhere. They're going to send her right out.
I'm gonna ask her.
Go ahead, do it.
That's fine.
I don't get to make those decisions unilaterally.
Putting 180 days in the state jail in lieu, with everybody's agreement,
No objection. Yeah.
in lieu of confinement in the county jail. Is this your understanding of the plan then?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
It's
I'll show you what's marked as State's Exhibit 1. Did you sign that?
yes, sir.
And understand it, discuss it with your attorney. Are the contents true and correct here?
Yes, sir.
States Exhibit 1 tendered into evidence
No, Judge.
without objection admitted. This also states if I follow this agreement, you have waived all rights of appeal. I am going to do this. Anything else to add by the parties?
No, nothing from the state,
If
Judge.
not, I'm going to find that there is sufficient evidence supporting the second amended motion to revoke probation under clause number 18-30652 to grant it by preponderance of the evidence or greater as allegations 1 and 3 are proven true. And your this second amended motion to revoke probation is hereby granted, and your probation is hereby revoked based upon the court's findings of these violations of probation. I'm following this agreement proposed and authorized by the parties. You are hereby sentenced to confinement in the state jail to a term of 180 days. You will be given credit for all time you have served. You understand what has happened today.
Yes, sir.
All right. Do well. Thank you. Okay, there's that one. Guillory? John Guillory, third?
Judge, he wants to be pro se, has been wanting to be pro se for since the inception of our.
What is this? What, for what? For trial?
Presumably you want a trial, Judge.
Okay, we'll do him last, okay? Nicole Treadwell was dismissed?
Yes. Or that
Okay, then I've got Michael Horn. John? Michael Horn?
No, that one's gonna be set on trial, trial case. I'm not sure if they stay on.
Okay, I need Horn. Michael Horn, please.
Forward.
It's another one of my favorite ones. Family violence. I just don't understand. Didn't grow up that way. Can't understand how it happens.
Yeah.
But it over and over again in this life. Wow. Twenty-six CR 387 is called. Michael Brandon Horn. Is that you?
Yes, sir.
You're here with Mr. West, your attorney, and the state's attorney. What are we doing today?
Your Honor,
now-
state has made an offer. My client is adamant to do this and want the trial, so set up for the trial.
We get plea rejection, it's on the record. Oh, yes, that's good. Okay.
So the victim in this case is a sibling?
Sister, yes.
Sister? Her perception of the situation is completely different than his. Let's see.
Yes, Your Honor.
She tried to flee from him, catches up with her, strikes her in the neck with a closed fist, attempted to get away, slapped her in the face, grabbed her by her hair, pulling her hair, drug her on the ground, then stood up, grabbing her and placed his arm around her neck. Placed the crook of his arm around her neck and squeezed. You know what you do when you squeeze somebody's neck? There's only one intent: to kill. Breathing comes in handy for humans. When you put somebody's hands around neck and squeeze, you're the only real reason you're doing that is to kill, that attempt to kill. So you're charged with the third-degree felony of assault, family violence. But this isn't your first rodeo, is it, with the law? See, you were convicted in 2019 in this court for illegal possession of controlled substance. After that became final, you committed the offense of evading arrest or detention and were convicted of that in 23 in the court next door. You're looking at no less than 25 years to life imprisonment. This is habitual felon. You understand? I can understand. Yeah, so and it is illegal and a violation of the bond conditions, or the bond condition, the orders of the court in all cases like this to have any contact with a victim. Do you understand that? Nor anyone on your behalf. If I find out about it, I'm going to ask the state to indict for another charge and add that, because you're not supposed to talk or have any contact with a victim. You haven't, have you?
No, sir.
Well, that lady wanted you prosecuted. And I can understand, especially if there's an attempt to kill.
Never
Set for trial. I'm sorry, you interrupted, but the grand jury accuses you, and that lady states you squeezed her neck. Were y'all just playing? That's a rhetorical question. You squeeze somebody's neck, there's only one reason to do that, an intent to kill somebody. Everybody on the planet knows that, apparently, but you. Set for trial. And let me find out from the state if he has any contact, because I'm going to ask that another charge be brought. Okay, that is all. Let's see. What's next, John?
Trial docket. I don't know if you want to give them one of their trial attorneys off the trial.
I'm talking about Jadrian Manning is what's next on this docket.
We'll talk.
Jadrian Manning.
This was reset for a couple of weeks ago. We're still working on that one. If we can get then we can get a few more weeks just to get that straightened out. It's old, but he was in.
Well, no, but nothing. It's we're a year and a half old. And he's sitting in the ground.
He was in mentally.
I know, but it's languishing. It's a year and a half. But it's assault on a peace officer. We're not gonna. What are we gonna do? We gotta. It's been a year and a half. Everybody knows where we would be heading. Come on.
Then give me 1 week, Your Honor. Be back the next Monday.
Reset unbook. Denise Woods.
Actually, I think it's the recases.
What are you gonna do with that?
Your Honor, one of them was an MTRP. We set that for a hearing. I've talked to my client. I've talked to Mr.
Are we ready for a hearing?
I don't know if we're ready.
State's not ready to it. I asked for at
When
least
can
3
you
days.
be?
Yeah.
I'd ask for at least 3 days notice.
I'm doing more than that. I'll pay you. Still need.
Thank you, Judge.
Be ready next week. June.
It depends on my officers or the witnesses' availability.
Yeah.
Judge.
Today is
That's the week I'm gonna be gone for my CLE.
No, that's.
what's available.
24th, yes, 20 through 24th. Yes, I'll be here on 24th. Yes. We get the 20th out here, but then I'm out.
Okay, but not the following.
Yeah, that week, anytime that week is good. Obviously, I'll print it today.
It's said it. I'll check on my witnesses. Well, it's a drug allocation.
Yeah, well,
It's a drug. It's a drug. It's a drug.
Yeah.
Everything here's.
Yeah.
It's got 3 cases in it.
yeah.
Smoking with methamphetamine. Just The odor arrived. It's just, I can smell it from here. And it's in the words. When do y'all want to set this for?
7:24.
Hmm?
7:24.
Y'all can speak if y'all want.
No, no objection, Judge.
That's week I'm here, Your Honor, so
Okay.
I guess I'll be available.
Except for then, thank you.
It's afternoon.
That's 3 days of this woods, right? I have. Brent. Hey, Renee Avila, what did we do? And Javante Bailey?
I believe he's signing up to plead to the misdemeanor. So, Mr. Bailey, you're asking.
The plea is complete, Ms. Compton, just let me know, so I'm doing the dismissal on ours as we speak.
Okay, and what's Renee Avila?
He's not gonna take the 2 years, but he wants to ask the court for a bond reduction. It's 30,000 at this point. 724.
Okay, let's see. And John Guillory?
He's the one that wants to be pro se, Judge. He's told me from the get-go, he wants to be pro se.
Pro se for 2. Okay, these are trials, right? Not MTRPs, trials, right?
Guillory, I suspect, but he's told me.
Okay, we're gonna take him.
He doesn't know at all.
Let me get to Bailey and Avila. Is Bailey ready?
Bailey's gonna be dismissed.
I don't have it. Yeah, I'll send it over.
Okay, Javante Lee Bailey to be dismissed, correct?
Yes, sir.
Okay, let me know when Renee Avila. And that's a,
He would like to reduce his bond.
okay, Avila.
From $30,000.
Yes, John.
Oh, no, yeah, he's right. He was here before.
Yes, sir.
Today. All right, where's state?
That's
That's me. She's good.
26 CR 273, 6 call. The defendant Renee Avila is here. He's with Mr. Turk, his attorney, and state's attorney. Defendant is charged with a 3rd-degree felony of engaging in conduct 2 or more times that constituted an offense under the Texas Penal Code. And by communicating directly with the victim in a threatening, harassing manner, texting, stating the defendant hates her, threatening to fight her, and he would urinate on her grave. Yeah, that's, I remember. Knowingly and repeatedly calling the victim's phone multiple times and going to and near the residence of the victim. And this constitutes, according to the grand jury, a engaging in conduct 2 or more times, which is a violation of bond or protective order rules, and thus is a 3rd-degree felon under the Texas Penal Code, section 25.07, which states, among other things, that it's an offensive in violation of a condition of bond set in a family violence matter. He directly communicates to a protective individual or a member of the family or household, or threatens, and those are Yes. Statutes that the legislature enacted to keep the family unit from being placed in violence. Okay, so what do you ask?
Judge, Mr. Avila is it Avila?
Avila.
Oh, that's what I thought. Is asking to reduce his bond to say $15,000, so we can get back to work. You know, not necessarily to support his family indirectly, because I mean, they need support. He's not supposed to contact his, I guess, ex-wife's wife.
She's my wife.
But, you know, right, but he does have an obligation to his children, to support them.
Have an obligation to her too.
He does, and I mean, but he can't contact her because of the pending cases, so that's what I'm saying, Judge, is.
Well, whose fault was that?
Well, Judge, this is a bond hearing. He
Well,
does have.
no, the point is
understand what
that you're asking for a reduction in bond, which would be him being a reduction of his requirements for being released, but he didn't follow the court's rules in the first place. That's why he's here. Why would he follow them now? If I reduced his bond, why would he follow any rules? I mean, he's in the grand jury indicted in, probable cause was rendered that he did not follow the bond or protective orders of a court.
That is the allegation, Judge.
Well, why would I think he would follow any I would get?
You want me to speak, Your Honor?
I don't care what you do. I'm just making a comment.
I would definitely follow the orders because.
You mean like,
No, because.
but you're here for a different reason. You're here for violating orders, you know?
Yes, Your Honor. I understand, John.
What's Stacey say?
Judge, if the court is inclined to grant the bond reduction, I'm going to ask for a GPS monitor before he is released, as well as no contact with that our complaining witness. But I am also looking at his history of non-compliance, and I did not have an opportunity to do any additional research as to his bond release.
Okay. Your request is denied, but I'm going to try to move this thing fast. When can y'all be ready for something? A hearing, a trial? Because he's been
He wants a trial?
sitting around a while.
At this point, yes.
Okay.
How long you been in jail?
I'm
5.5 months, sir.
So I guess we'll just reset it for trial, Judge.
Okay, well, I'm placing on the trial docket, okay?
Yes, sir.
And listen, try to get that done that way. Thank you. That is all.
Thank you.
Devontae Bailey, he's. I've got some. Going back, I've got John Dixon. What am I gonna do on that?
One, trial docket.
Okay, here's Joey Childress. What do we do on Joey Childress? That's Don's.
So we're ready to go to trial. That's the main announcement. There was an offer made, 12 years. It was.
Okay, are you representing him or Don? You are?
Joey Childress. Yes, sir. That would be me.
Oh.
Docket.
Yeah. Well, Joey Childress.
And he's in custody, Your Honor.
Okay. So, yeah, it's well over a year old.
Yes, sir.
And that's what we will do. This place on the trial docket.
Yes, sir.
He's number 2, I believe, today.
Oh, he's,
You've already numbered him.
oh, okay. Okay, he's the second one
Okay.
today. I guess I was pulling that out of the trial docket.
Yeah, I think.
Here's, I think Jeremy Broussard as well.
Yeah,
Yeah, that's it, the trial, your number something. Three. Terrence Jarman. There's that one. John, you get it. Matt, hey Brent, on John Guillory again.
Yes, sir.
I got two cases and he wants a hearing. Pro se, right?
Yes, sir.
Okay.
You go say.
I have some dismissals here on Kendrick Antoine. Am I ready to dismiss that?
Yes, Judge, he pleaded to one case.
Yeah, but
Earlier.
everything else is done, right?
That's my understanding, Judge.
Okay, good. That means.
He'll be back. But I'm going on fix.
That case is hereby dismissed. And that's Kendrick Antoine, 25 CR 1607. Javante Bailey, a dismissal.
Yes, sir.
Good for that?
Yes, sir.
25
That's defense counsel.
CR 876.
Okay.
Last case
I mean, technically, once you're not dismissal, I'm not defense counsel.
is dismissed. I've got Wyman Clover. Like rolling in the clover, 24 CR 807. A motion to dismiss. Good, Mr. Laird?
Yes, Your Honor.
All right, I'm signing it.
You know, we want to get me external sitting on the sofa. That's what I was working with. Stage two, interchangeable.
What are we doing, Glover Jones? On Jones, theft of person.
That's the one you rejected, Judge.
I rejected that one, right? That's okay. That's Kimler? Yeah.
Yes, sir.
All right. Yeah, guy, I think he said he wasn't guilty, right?
No.
No, he just didn't like the offer. He was habitual and you said no.
Oh, yeah. All right. So now I have two cases